Specifically, the minister changed her position from abiding and doing nothing. So she didn't file the explanatory affidavit to explain her decision to abide, for example. And then she changed her position to what I call notionally abiding, because in fact, when you look at what the minister has done, the minister is opposing the relief sought actively and seeking to place evidence before the court. The minister also ignored various directives from the court to file submissions. And we would submit that if one looks at the affidavit supporting the condemnation application together with the minister's submissions, there are in fact contradictory versions about why the minister currently participates in these proceedings. So on balance, we would say this is not acceptable conduct by the minister in circumstances where it's been a year since the High Court judgment, and we would then submit that condemnation should not be granted. But back to the true issues in this case. This case has its origins in the particular circumstances in which my clients found themselves when they were expecting their first child. Mr. and Mrs. van Wyk were both professionals at the time that Mrs. van Wyk felt pregnant. Mr. van Wyk was a lead specialist in a financial services company, and Mrs. van Wyk was and is the CEO of 2 successful independent businesses. The van Wyks were faced with a quandary. If Mrs. van Wyk stayed home with their child after he was born, her business would not survive her absence, and that would have a huge financial impact on their family. In contrast, Mr. van Wyk was employed by a company which was stable and which had a maternity policy that allowed 4 months paid maternity leave in line with the Basic Conditions of Employment Act. So if he was able to take 4 months off work, he could return to his position thereafter relatively unaffected. So the van Wyks decided that what was best for their family was for Mrs. van Wyk to go back to work soon after the birth of their son, and that Mr. van Wyk would stay at home and care for their child in the first few months of his life. So he applied to his company for maternity leave and was told that this was only available for women, and that fathers could only receive 10 days paid parental leave in line with the Act. In effect, what happened is that Mr. van Wyk ended up having to take unpaid leave in order to stay home with their child. So as a family, they were then penalized for making this very deeply personal choice about how to structure their family. And while, let me say that all of these facts are contained in the papers in the founding affidavit in the High Court, which is in volume 1. While in South Africa, the norm may still be that mothers in general choose or are forced by circumstance or societal pressures to stay home with their babies for the first few months after birth, the van Wyks are part of what we submit as a growing group of young South Africans who see their roles in the family unit as less gendered and more equal. So in light of their experience, the van Wyks brought this application to challenge the particular discrimination that's inherent in Section 25 of the Act. The van Wyk applicants are concerned specifically with remedying gender discrimination. That is their personal experience of the application of Section 25, and that's what they want remedied by the court. So our case for the first and second applicants focuses on Section 25 of the Act, and we will ask this court to declare that section unconstitutional and invalid on the grounds that it violates both equality and dignity. But since launching this application, the case has grown as other interested parties have joined the litigation. And so the case before you now asks this court to confirm an order that also declares sections of the UIF Act unconstitutional, and it asks this court, and it makes an order in relation to parental leave for adopting parents and commissioning parents. I am only going to deal in the interest of time with the case as it relates to my client. Ms. Barnes for the Commission for Gender Equality will address the issues around UIF and adoption. So with that introduction behind me, my address today will deal with the following issues. I would like to look briefly at Section 25 and say why that section is unconstitutional with specific reference to equality and the equality and dignity rights in the Constitution. I'll then look at the relief sought by the van Wyk applicants and specifically the interim reading in that we ask for. In doing so, I will address the minister's argument that no interim reading in should be granted in this case at all. Now, Justice, you will see that the relief sought by the Van Wyk applicants differs slightly from the relief sought by the the Commission for Gender Equality and from Sonke Justice. But in fact, all three applicants agree that Section 25 and the provisions which regulate the taking of parental leave in different circumstances are unconstitutional, insofar as they preclude men from sharing in parental leave after the birth or adoption of a child. And that is why we seek to have this court confirm the High Court order. Now, if I may then turn to look at Section 25. Section 25 is situated in the context of a series of provisions providing for parental leave after the birth or adoption of a child. As the High Court pointed out, the section is designed as a policy choice to provide a minimum period of leave that an employer must give an employee in certain circumstances related to the act of having or adopting a child. Importantly, there is no obligation, and this is an important consideration to keep in mind in evaluating the relief down the line, but there is no obligation on an employer to pay an employee during this period of leave. But employees, there is an obligation to give leave. So the Act attempts to protect the parties concerned in relation to leave, not in relation to being paid by their employer. But then employees are entitled to claim from the UIF during that period, and that's dealt with under the UIF Act. And I'll come to that in due course. Section 25, if one looks at it, deals broadly with four different things. Firstly, it provides for maternity leave for mothers who are about to have or have given birth. And so in that regard, you'll see that Section 25(1) provides that an employee is entitled to at least 4 consecutive months maternity leave. The language of employee is used in this provision, but the heading of that section is maternity leave, suggesting that it applies to mothers only. Section 25(2)(a) reads that an employee may commence maternity leave at any time from 4 weeks before the expected date of birth, unless otherwise agreed with the employer. So that's the first thing the section does. The second thing the section does is it provides for leave specifically designed to address the physical impact of pregnancy and birth on the health and body of a woman. And you'll find this in Section 25(3) and 4. The High Court refers to this helpfully as the physiological dimension of pregnancy. And that is in relation to the argument that a woman requires 6 weeks for her body to heal after giving birth to a child, and the Act seems to provide specifically for that. So 25(3) precludes a woman from working for 6 weeks after the birth of her child, unless a medical practitioner or a midwife certifies that she is fit to do so. And then Section 25(4) provides that an employee who has had a miscarriage during the 3rd trimester or bears a stillborn child is entitled to 6 weeks after the miscarriage or stillbirth. So these provisions we submit are not related to parenting leave. They are about the physiological dimensions of pregnancy. For the sake of completeness, I also point out that 25(a) of the Act deals with what is called parental leave. And that provides that an employee who's a parent of a child is entitled to at least 10 consecutive days leave. The way this has been interpreted is that traditionally a mother would take leave under the 25, the maternity provisions, and a father would get 10 days leave under 25(a). So the family unit as a whole would get 4 months plus 10 days. So those are the first two things that the section deals with. The third thing that the section deals with is with notification requirements to your employer. And Section 25(5) says that you have to give notification to your employer at least 4 weeks before the child is due or as soon as reasonably practical. So that is about notification. The fourth thing the section deals with is the payment of maternity benefits. And all it says in Section 25(7) is that the payment of maternity benefits will be determined by the minister subject to the provisions of the Unemployment Insurance Act. Okay, so that's a broad structure of Section 25. There are other provisions that my colleagues will deal with that deal with adoption leave and commissioning parent leave, but I'm not going to deal with those. I now turn to deal with the specific rights at issue in this case. In preparing for this hearing, it occurred to me that the discrimination inherent in Section 25 was so obvious that one almost needs to read out that provision for you to understand that there is not just a differentiation between birthing parents and non-birthing parents, but that discrimination is unfair. But I think that it's also important to look at the provisions themselves and go through in some level of detail, so I will do that. The first section of the Constitution that we rely on is Section 9. Section 9 is the equality provision, which provides in relevant part in Section 9(1) that everyone is equal before the law and has the right to equal protection and benefit of the law. Section 9(3) of the Constitution provides that the state may not unfairly discriminate directly or indirectly against anyone on one or more of the listed grounds, which in this case include sex and gender. And then in terms of Section 9(5) of the Constitution, discrimination on one or more of the listed grounds is unfair unless it's established that the discrimination is fair. So once there's discrimination on a listed ground, as we say there is in this case, there is a presumption that the discrimination is unfair unless the state establishes that it is fair. And so the onus is then on the state to show this court that the discrimination in Section 25 is fair, and we submit that it has failed to do so. Our courts have consistently emphasized the importance of the right to equality and the distinct place it finds within South African jurisprudence. Our heads of argument from page 9 onwards summarize this court's equality jurisprudence. And I do not propose to repeat that jurisprudence here for the sake of time, but I would like to make reference to what this court has said in Fourie. In Fourie, this court noted that equality necessarily requires giving recognition to the heterogeneous nature of South Africa's diverse society. And I quote, "Equality means equal concern and respect across difference. It does not presuppose the elimination or suppression of difference. Respect for human rights requires the affirmation of self, not the denial of self. Equality, therefore, does not imply a leveling or homogenization of behavior." And that's in Minister of Home Affairs versus Fourie. These values referred to in Fourie set the framework through which we submit violations of the right to equality must be adjudicated. It's clear to us, and the High Court accepted, and indeed even the minister appears to have accepted, that the Act clearly differentiates between mothers and fathers and between mothers who give birth and those that do not. And you'll find that in the High Court judgment at paragraph 12. So the question of differentiation does not appear to be in dispute. And the facts of the Van Wyck's particular experience show that the practical way in which the section is implemented is one that differentiates. Now, this court has held that what the question that must then be asked is whether the differentiation is rational. And the state is therefore required to act rationally and cannot regulate in an arbitrary manner or manifest naked preferences that serve no legitimate governmental purpose. And there are many judgments in which this court has said that, but I shall refer to Prinsloo versus van der Linde, which is a 1997 case of this court, volume 6, BCLR 759, at paragraph 25. So it's incumbent upon the state to justify and to justify cogently and precisely when it seeks to confer benefits or obligations on one category of persons as opposed to another. And we submit there's no rational basis for the differentiation that's been provided by the minister, and that it does not serve a legitimate purpose. The minister in the High Court contended somewhat obliquely that the purpose for the differentiation in Section 25 was to protect pregnant women, and perhaps in relation to 25 or I would submit that perhaps in relation to 25.3 and 25.4, one could say that is correct because of the physiological impact of pregnancy. But those are not the core provisions that are being challenged in this case. We know that the facts of the Van Wyck's own case are that Section 25 did not protect Mrs. Van Wyck. She was discriminated against because she was not entitled to have her husband take paid parental leave, and they accordingly, as a family, had to have him use his annual leave, which was unpaid, in order to stay home with their child. So she was discriminated against. Mr. Van Wyck was discriminated against because he was precluded from taking parental leave to care for his child. And in fact, during the course of this case, the Van Wycks have had a second child since the High Court judgment, and Mr. Van Wyck has had to do exactly the same thing again. Now, the provision of parental leave is absolutely critical in the family context, so it's a necessary and important purpose. But the problem with the arguments that the minister put up in the High Court was that the purposes provided were generic. And this court has held on more than one occasion, but specifically in Van der Merwe, which was a case about the Road Accident Fund, that the minister is not entitled to rely on a generic purpose, such as addressing the discrimination of childbearing mothers. So that's a broad, generic purpose. And this court has said you're not entitled to do that in justifying why Section 25 should differentiate between various categories of parent. In Van der Merwe, Moseneke, Deputy Chief Justice, as he then was, held that what was important was that a specific purpose be provided for the provision. So in this case, the issue is not about the general purpose of addressing past workplace discrimination or discriminatory circumstances that currently besiege mothers who have given birth, but the true question is whether the differentiation between mothers and fathers in Section 25 specifically serves that or any other legitimate purpose. And we submit that it does not. The problem with Section 25 is that it entrenches sexist norms, outdated societal practices, and it affirms the uneven burden of childcare, where women are expected to forego their career aspirations in order to assume the historically female-dominated role as a primary caregiver. Now, this court has had occasion to comment on the unequal burden placed on women in Hugo, where Justice Goldstone remarked on behalf of this court as follows, and I quote, "The reason for being responsible for children makes it more difficult for women to compete in the labor market and is one of the causes of the deep inequalities experienced by women in employment." And that's a case that's referenced in our heads at paragraph 44. And we know this to be true in the case of Mrs. Van Wyck, who stood to lose her business if she was the parent that had to stay home for those 4 months. So it's very difficult to fathom how the differentiation in Section 25 ameliorates the social stigma surrounding women who are both mothers and business people. In the High Court, the minister accepted that subsections 25, 3, and 4, which deal with the physiological conditions, illustrated a clear legislative intent to provide a woman who's given birth with time to recover physically. And so one couldn't, we submit, contend that is relevant to the question of parental leave. It's very clear that those two provisions deal specifically with the bodies of a woman after childbirth. So I would submit we have clear differentiation, and that there's no rational basis for that differentiation. That then gets us to the question of whether the differentiation in question amounts to unfair discrimination, as contemplated by 9.3 in the Constitution. And that is discrimination on the basis of gender and sex. In our heads of argument, we go through the Harkson test in this regard. I won't go through it now, but it's at paragraph 54 of our heads. And we submit that the test has been met and that discrimination on the basis of gender and sex is very clear in this matter, and that the onus fell on the minister to plead material facts to demonstrate that the discrimination was justifiable. The minister has failed to do so. That on its own should be the end of the matter. Indeed, this court has made it clear that the absence of evidence or argument in support of the limitation of a right has a profound bearing on whether such limitation is justified. Nevertheless, the facts of this matter, coupled with just common sense and reason, expose why unfair discrimination is unjustified in this case. And so we would submit the High Court was correct in our submission in finding that there was no justification for the unfair discrimination, as none had been provided, and that the discrimination inherent in the act was unconstitutional. We also rely on the right to dignity in Section 10 of the Constitution, and self-evidently, it's not only the equality rights of the first and second applicants that have been infringed in this case, it's also their dignity, their ability to make very personal, intimate choices about their family structure has been impacted by Section 25, and that infringes their dignity. Dignity, this court has held, is a right that's necessarily and closely intertwined with the equality right. And we submit that the High Court correctly found that the act infringed a father's right to dignity, as it rendered his involvement in early parenting as marginal, and further violated both parents' right to dignity as it stripped them of this personal choice I described. So for all of these reasons, we would submit that Section 25 is in conflict with Section 9 and 10 of the Constitution, and that the order of the High Court should be confirmed. That takes us then to the question of remedy, which we would submit should really be a primary focus of the court in this case. Should the court find that the impugned provisions of the Act are unconstitutional and invalid, then the Constitution requires this court to make an order which is just and equitable. We've asked this court to declare Section 25 unconstitutional and invalid, and to suspend the declaration of invalidity for a period of 2 years to allow Parliament to cure the unconstitutionality. We have then asked for a reading in, an interim reading in, to allow Parliament an opportunity to cure the defect and protect parties harmed by the unconstitutionality in the interim. Now, before I come to what we asked to be read in, I want to just respond briefly. The Minister says that reading in this case is inappropriate, and that this court should not make a reading in, should not give an interim reading in as part of its remedy, but should simply declare the provisions unconstitutional and leave the rest to Parliament. We filed submissions, as I said earlier, in response to the Minister, and so I'll refer to that. But I just want to deal with that, with the interim relief question. First, the fact that this court may grant an interim reading in does not curtail Parliament's powers to amend the legislation in whatever way it wishes. I can see that there may be cases in which interim reading in is not appropriate, but in this case, it is appropriate. And the starting point, I would submit, has to be that this court must provide relief to those feeling the impact of the unconstitutionality. This court is enjoined to provide effective relief. An interim reading in does this. And I see I have 5 minutes. So I'm going to refer the court to Gaitner versus Minister of Finance, 2014 1 SA 442 at paragraph 83 and 84. And in that case, this court said reading in is temporary precisely because the court recognizes there may be other legislative solutions, and those may be best left to Parliament to contend with. And the other case to refer to is Amabungani versus Minister of Justice, which is 2021 3 SA 246 at paragraph 143, where this court emphasized the importance of providing an equitable remedy, even when to do so was complex. And that's important because the minister tells you that the various options for reading in and for remedies in this case mean that it's too complicated for this court to provide interim relief. That is not correct. This court should not shy away from protecting vulnerable parties in the interim period while Parliament corrects what this court says, or I hope it says, is a constitutional defect. And in the Amabungani case, the court said, the odd instance may require a singularly creative remedy. In that case, the court should be wary not to self-censor. Instead, it should do justice and afford an equitable remedy to those before it as it is empowered to. In the words of Cameron J., the bogeyman of separation of powers concern should not cause courts to shirk from their constitutional responsibility. If interim reading in is not granted in this case, this court will be leaving the applicants and all others like them with no relief for at least another 2 more years. And it will allow the perpetuation of an unconstitutionality. So a remedy is required. The question that this court will have to answer is what remedy? We would submit the High Court order, while not perfect, does attempt to meet the various problems in the legislation. And that's why we ask for confirmation of the order. We do point out in our submissions that the High Court order removes the right to the 10 days of parental leave in 25A, and so effectively diminishes the overall amount of leave that a family would have been entitled to in the Act as it stands. So that's something to bear in mind. But in truth, the relief sought by the first applicants and the Commission for Gender Equality doesn't differ that markedly from that of the High Court. We have a different view on Sonke Justice's relief. They asked for both parents to be able to stay at home concurrently for 4 months each. We think that while that is a wonderful move forward from a social perspective and a society, it may be asking this court to go too far. And that may well be a policy choice that's more appropriately left for the legislature. In view of my time, which I think is about to expire, I will leave any other questions on which is the appropriate remedy and what relief is required to any questions that the court may have, and I'll try and address them there. Thank you.
Thank you, Ms. Rajab. But Linda, do I understand your argument correctly that if the Van Wyks come home on Section 9.1, it's not necessary to get to 9.3 read with 5, sub 5?
Yes, I think that is correct, Justice Madlanga.
Oh, all right. I forgot my other question. Colleagues?
May I ask on remedy, please, Justice Madlanga? Raja Badlander, is there room for an argument to be made that if we go the route that the High Court and you and CGE basically propose, that parents must share the four months as their circumstances deem appropriate? Is there room for an argument that it will in fact force the parents to make a choice whereby one of them will have to carry the burden, and that inevitably will be the mother, the wife? Is there room for such an argument that it leaves them all in a less of a quandary than they have at the moment, far less, but still some quandary? Is there an argument? Is there room for an argument like that? Thank you.
Yes, Justice Majid, I think you're right. I think what your question raises is this this sort of strange position that we're in, where what we're looking at and what the Constitution provides is not what's reflected in society. So we know that the truth is that whatever this court says, it is a step towards changing societal norms, but it's not going to happen overnight. We also know that the truth is that more women will, or that women will continue to be the primary caregiver for various reasons. But South Africa is, I would submit, inherently still a very patriarchal society. We know this. And I have great hopes that in the next generation, that the impact of a judgment like this will facilitate men thinking differently about their roles. And maybe not in the next generation. I mean, the Van Wyks are a young couple, but they're having children and they would like to change. So I accept fully that there will continue to be pressures on women to bear the brunt of this parenting load. The court can't really change this, but what the court can do is to try and facilitate change and to provide a basis for change. And that's what we're here asking the court to do, is to remove a legislative provision that stops progress and that stops people that are trying to act in a less gendered way from doing so. So Justice Majid, when the High Court says that parents can choose, make an election on how to share the 4 months leave, you're correct. Many families will simply just say, we're not sharing the leave, the woman is going to stay at home. But there will be some families that choose to use it. And that is the sort of forward-looking nature of the relief in this case.
Ms. Badlander, I wanted to just find out the proposed remedy that it's in para 79 of your heads. And there you've raised the issue of the High Court having taken away the 10 days that had been granted in terms of the Act. But you said there under para 1, section 25(1), you're talking about 4 months, nothing about the 10 days. Do you want to say anything about that? And the 4 months that is proposed, will that take into account the 6 weeks that is supposed to be not shared, or what should we do about those things? Or would it be correct if we leave it like this?
Thank you, Justice Nhlanhla. We have grappled with the various permutations of how to seek relief in a way that protects everyone in this process. And I certainly don't suggest that it's easy. Our relief, that our interim reading in that we seek, really tries to fix the gender discrimination aspect of this case. So the Van Wyks came to court saying men and women are treated differently in our family structures, and we want to fix that. So what you see in on the last page of our submissions is really an attempt to fix the gender discrimination. So every reference to maternity is replaced with parental leave, etc. But, and 25A, which we did not deal with, and perhaps we should have, 25A is the 10 extra days that's provided. The effect of the High Court judgment is that everyone just shares 4 months, but the 10 days is deleted. So we submit that perhaps the best way of doing this, there are various ways in which this court can do it. You can either confirm the High Court relief and cater for the extra 10 days of parental relief. So refuse to delete section 25A, but provide a reading in, for example, that in 25A says a parent who does not remain at home, for example. In fact, that as I'm saying it, I'm thinking that probably won't work. You may just have to lose the 10 extra days, unfortunately. But it is a difficulty with the High Court order that we've highlighted. If you want to try and use the High Court order, then you simply have to say there's 4 months, you split it amongst you as you wish. That, of course, does not take into account the 6 weeks that a woman is not allowed to go back to work. So when we considered that, we thought, well, perhaps what would be appropriate is that you remove the 6 weeks. You accept that every woman who gives birth is entitled to 6 weeks leave. That is not parenting leave. That is leave for her to recover from the birth. Now, if you do that, there are various options open to you. The one is you can say, we remove that 6 weeks, and every family gets 4 months to decide how they want to deal with. So father can stay home for a full 4 months, a mother can stay home for full 4 months, and in addition, a mother will get 6 weeks. If you do that, then you're entitling a family to 4 months plus 6 weeks, effectively. And it would be for this court to decide whether that goes further than they're willing to do. But to my mind, that would be an option that takes care of both the physiological condition of the woman and parenting leave. One would also have to consider what the impact of this is on mothers in situations in which they don't have a partner who wants to take leave. So you would have to make sure that an order like that caters across the board, whether or not you are sharing the leave with someone. And because of these various permutations, we think the simplest fix, and that's what we submit anyway, the simplest fix is to fix the gender imbalance, to accept that the 6 week leave must just be part of that, of the provision as it stands, but to make sure that if a male partner wants to take 4 months of parenting leave, he is entitled to do so. And then allow the legislature time to grapple with the more complex issues around how you cater for everyone. One of the difficulties with the High Court order as it stands is really, I think the High Court was trying to find a solution that met all of these different concerns, except for adoption, which Ms. Barnes will deal with. So, for example, the issue of sharing was not something that any of the parties had raised. The High Court attributes that to the first and second applicants, but that's incorrect, as we point out in our submissions. The first and second applicants never suggested sharing the 4 leaves, the 4 months. We always simply said, don't discriminate on the basis of sex or gender. So, Justice Mhlantla, I'm sorry, I don't have a perfect answer to that question, but we submit that our relief at least answers the discrimination aspect of the case.
No, thank you, thank you, thank you.
Ms. Rajab Badlender. Because of the difficulties of, the various permutations and, I thought that perhaps it would be better for us to afford the legislature an opportunity to look at how to fix this. So if we are with you on constitutional invalidity, to suspend that order and allow legislature to do that. Apart from the questions that you've been asked by Justice Majid and Justice Mhlantla, I'm worried about coordination as well. I'm worried about coordination because you might find that there's 2 employees work for different employers. Who's going to coordinate the sharing? I know that in your heads somewhere, or it was Sonke's heads, there was a proposal that the parties need to notify their employers who's going to take the amount of leave and all of that. And I thought that it might perhaps be burdensome now on the employers, because they would then have to employ somebody else, to sort of deal with these kind of things. And apart from that, I was wondering whether we are actually not prescribing to the legislature on how to deal with this. That's my anxiety.
Yes.
With
Thank
going further than just making a declaration and suspending it.
Thank you, Justice Cheekney. I think that those are genuine issues to raise. Can I say this first of all? We would submit there's no situation in which this court should make a finding of unconstitutionality and suspend without finding the interim relief. There must be some protection afforded to families in the interim. That is because it will take time. At a minimum, it's going to take 2 years. We know that pending before this court is another matter in which the time has come and gone and we still don't have an amendment to legislation. So it is entirely possible that this is going to take a long period of time to remedy. So my first point is, whatever this court does, it must make some form of a reading in. We would submit that the first and second applicant's reading in, which seeks to cure only the discrimination between men and women, is the simplest way to do it, because it will allow men and women to choose who's going to stay home with their families, and it doesn't preclude, importantly, it doesn't preclude men from staying home with their child after birth. It also doesn't tamper with Section 25(7) of the Act, which says that the payment of maternity parental benefits will be determined by the minister. So it doesn't do significant damage to the statute as it stands. My colleagues for the CGE and for Sonke will argue strongly, I'm sure, why I'm wrong on this. But our relief is really crafted to fix just the discrimination problem and to allow the legislature then to deal with all of the various permutations of what may or may not happen. So that's the first point. The second part of the answer is, in relation to the question of employees, I think there are valid questions around how the High Court order will be implemented in relation to sharing. And so the High Court order doesn't tell us practicalities of how that will work. But one would imagine that if you had 2 parents, for example, and they decided to for the mother to remain home for 2 months and the father to remain home for 2 months, and assuming each of them are employed by different employers, they will simply notify their employers under the Act that one of them is taking January and February off and the other is taking March and April off. And those two employers will then be required to give them 2 months separately. Assume they're separate employers, they will get 2 months off. So there are situations, it's not overly complicated to do that. There would have to be a process in which the UIF aspect of the administration is brought into this world. And I must say, I'm certainly not skilled enough to suggest to this court how that could happen. So we have actually said coordination, what we call the coordination problem, is an issue, and that our relief would allow this court to avoid that issue and give time while still protecting people impacted by the unconstitutionality. So I accept your point, Justice Chikli. I think there's validity in it, and it's a complicated question. I would submit that our relief meets that question.
To add to that, as I was reflecting on this remedy, I was just thinking that, we know that, yes, in organized and structured work environments, it would be easy for an employer to be notified, as such as said, by one of the parties. But in an unstructured environment, in this country, we've got parents who work in unstructured environments. They should be structured, but we know the reality is that they are not structured. I'm thinking here of people who work in people's homes, who are not registered, and all of those things. And when we think of legislation, we have to think about the whole South African citizenry. We're not restricting it to only structured environments. And we then, in their instance, if we do accept the proposal that you've made onto remedy, would we be saying that they are covered?
Yes, our relief would cover structured or unstructured environments. Long as,
well, in terms of practicalities, the coordination, I'm still talking to the coordination, how that will be coordinated practically.
Yeah, Justice Chigi, I think in truth, there are a few things that we must bear in mind about how the UIF process works. When one thinks about, and it's important to think about these practicalities as you raise them, if one were to apply for UIF for parental leave, you are only entitled, as I understand it, to get up to a maximum of 66 or almost a third of your salary, with a cap of approximately 17,000 Rand a month. So this is not going to be an attractive thing for most people to want to get, because they're effectively, even if they claim from UIF, they're not getting their full salary. So I think that the numbers of people that we're talking about here are perhaps less than would at first glance appear. So I suspect when you put that together with the social norms, asking a father to stay home for 4 months, but also asking them to take a cut in their salary for those 4 months, go through this process of notifying the UIF, which we know is simpler in a structured environment, but in an unstructured environment requires an individual to go down to the UIF offices, stand in queues, fill out forms, wait, have a bank account, wait for a resolution from the UIF, wait for that money. It's not a quick or guaranteed thing. So I accept fully that the order of this court may operate differently on South Africans depending on where they work. I think that is why our relief is the most acceptable relief before you, which is to say, fix the discrimination, protect parties, as this court has said in the Bay judgment, don't allow an ongoing violation, and allow Parliament to do the work of fixing the problem, having consulted extensively and taking into account all of the evidence that the Minister hasn't placed before this court. So yes, Justice Chiki, I hope that answers the question.
Thanks, Ms. Rajab Badlender.
Thank you.
Miss,
Can I? Okay.
okay, thank you, Justice Colopin. Mr. Rajabadla, there has been some debate amongst council regarding the impact on the fiscus of any order that this court might make. The order that the first and second applicants propose in terms of 4 months leave shared between the parents, what impact would that have on the fiscus?
Justice Theron, let me just start by saying the relief that the first and second applicant seek is not sharing, but is an either-or situation. So it's just not to preclude a man from being able to take that leave.
Wait, sorry, before you go, when you say not sharing, so 4 months, can they choose between the two of them? If one takes 1 month, the other takes 3, that's what I'm asking.
Yeah,
No.
that's the confusion that comes in with the High Court judgment. The High Court said that is the relief that my clients wanted. It's not. That is the relief that the High Court came up with. The relief that my clients wanted is simply to say, if a man wants to take the benefit of parental leave, he's precluded from doing so under the Act. So we must fix that. So that's why I call it the fixing of the discrimination problem. That's our case. The High Court tried to, I think, find some sort of a middle ground where it dealt with a whole series of problems. And the High Court said, just let parents make an election and choose amongst themselves how they will share that 4 months. But that was not our submission. In the event that parents, let me start with this. In the relief that my clients seek, there should be no impact on the UIF, because where a mother would have claimed 4 months, now a father might claim 4 months. That's effectively the situation. There might be minor budgetary implications that are unforeseen, but really there's no big issue there because you're replacing one parent with another. But on the general question around budgetary implications, I would like to say this. The first thing is that in Blue Moonlight, this court said, if it's not okay to place vague evidence before a court of budgetary implications and effectively scare off a court from making any order because of a budgetary or resource implications, you must be specific about the evidence that you place before the court. And in Blue Moonlight, the minister had placed some evidence, or it was a city, I think, had placed some evidence before the court, but it was very general. So the court there said, you can't put vague evidence before us, you must put proper specific evidence. In this case, we have no actual evidence before us. We don't, the minister in their condemnation affidavit, I think it is, said they were arranging consultations with actuarial scientists. Well, we don't have any of that information. We don't have budgetary implications. We don't have evidence. We don't have actuarial evidence. We don't have statistics about how many people currently claim for maternity leave and how many men they think might be, willing to take this up. So really, this court is being asked to make these decisions in a vacuum. And that's why we suggest that that the order that we seek is appropriate. It's what the court has in front of it in relation to budgetary concerns is not enough. And in reality, as I said, we know that most men are not going to claim this benefit. And I know I'm giving evidence from the bar, but that I would imagine, given the series of cases of this court that look at gender discrimination, for example, would show that our society is inherently patriarchal. So I think,
Mr. Rajabadlan, I'm sorry to interrupt you. The fact that this court can't close its eyes to the impact of the fiscus that any decision that it might take might have, even if, as you say, insufficient evidence regarding that has been placed before us. But we cannot close our eyes to that. We have to be cognizant of, will the order we make have budgetary implications? Are the implications such that might cause a collapse or chaos within the system? at least at that level, we must have regard to that.
Yes, I accept that, Justice Saran. And I accept that, and I think that is the weakness of what happened in the High Court when that evidence should have been led and wasn't by the minister. But the relief that we seek as the first and second applicant does not have any budgetary implications, because really, as I said earlier, we're replacing one parent with another. So it's 4 months that the UIF would have to have had compensated someone in that family unit. I think the question, Justice Saran, sorry.
Please proceed.
The question is, how does this court take into account budgetary considerations in the absence of any evidence from the minister about what those implications are? So all we have literally is the minister's submissions that simply say in one paragraph, I think it's paragraph 10, it simply says, it quotes from the UIF report, and it now, for the first time at this late stage, puts before the court what's in the UIF report 2021, 2022, I think. I'm just looking for the relevant spot. But it's here, sorry, it's paragraph 23 of the minister's submissions, page 10. It's the 2020-21 UIF report. That's the extent of what we have. And it really says, this is how much that we've paid in maternity benefits in this year, in this financial year. And this is the monetary value. The monetary value of maternity benefits was the second highest value of benefits paid by the UIF. But it doesn't tell us what is the overall amount of money the UIF has, for example. So I don't.
It does refer, I think the respondents refer to an amount of 3 billion. And I'm not sure what the 3 billion covers.
But isn't that
I'm not sure if that relates to if the benefits were increased in respect of adopted parents, surrogate parents as well.
But isn't that precisely the point? The minister now comes and places his submissions before you, and in submissions, not an affidavit, and says, gives you these numbers. But it's very difficult to ask this court to then take these numbers and try and work out what the impact on the fiscus is going to be. I would submit that what you have before you is not sufficient to do that. So that is something that we would suggest requires mention by this court, because it places this court in a very difficult position, not to evaluate the relief that my clients seek, which is unimpacted by that, but the relief that the other applicants seek. I think it's best if I leave that to Mr. Boda to answer, and Ms. Barnes, who has actively opposed the minister's application on this score. But the bottom line is, if this court...
And then just to follow up, yes, just to follow up on the questions that were asked by my sisters, Justice Chikli and Justice Mtlantla, relating to the 6 weeks and the 10 days. If this court is with you that the order in respect of the parenting needs to be confirmed, what must the court do? Must an order specifically be made about the 6 weeks? Because the 6 weeks is only the birthing parent is entitled to the 6 weeks, because that's an apportionment of the time to allow the body to recover. Do we take the 6 weeks out of the 4 months? Because if for now I understand that the maximum time that a mother can get is 4 months, and then the father can get the 10 days. So together it's combined 4 months and 10 days. If the impact of our order is to grant the parents between the two of them now 4 months and 6 weeks, that undoubtedly would create a burden on the fiscus that would not have been catered for.
Yeah, Justice Saran, our relief simply continues the structure of the Act as it is, which is to say the 6 weeks for the mother is bound up in that 4 months. So she will get that 6 weeks no matter
I'm
what.
sorry to interrupt you. So that means the father cannot, because I heard you earlier say the mother can choose to take 4 months or the father can take 4 months. So on that argument, the father cannot take 4 months, request 4 months leave.
Yes, if you in a perfect world, I would have said that what I would have liked for this court to do to protect all parties concerned is to carve out that 6 weeks and say all mothers are entitled to 6-week care for physiological recovery, not parental care, and that all parents are entitled to 4 months. That is 4 months plus 6 weeks. But I accept that that may be a stretch too far. That effectively,
You see, then that is then going towards policy. Because the policy content of it is that the paternal leave is between the two parents, it's 4 months and 10 days. So surely if this court has to extend that period, it's then going into policy.
well, that is what this court will have to decide, Justice Theron. It is a similar argument, well, it is a similar debate that this court will presumably have with Ms. Letzler, who asks for 4 months plus 4 months for both parents consecutively. And the question then is, does that ask this court to go too far? Are you then legislating policy choices? That is why we have effectively simply tried to fix the problem of fathers not being able to get any leave. But you are absolutely right that what that will mean in effect is that a father gets 4 months less. I'm just thinking if I'm actually correct on this. A father would, under the Act, as under our interim relief, 25 would then read an employee who is an employee may commence maternity leave. Sorry, give me 1 second just to get this correct when I make the suggestion to you. An employee who has given birth or whose partner has given birth is entitled to at least 4 consecutive months. The employee in that situation who has given birth, her 6 weeks is included in that 4 months. But the question then is whether the partner whose wife has given birth is not simply entitled to 4 months, and that would allow her separately to claim 6 weeks. Would that have an impact on the UIF? Possibly, but not a huge impact. I would have said 6 weeks rather than 4 months. But I see the problem.
Yeah, this is my last question, and I'm sure counsel for the respondents will assist us. But do you understand the respondents to be opposing interim relief in respect of the relief that the applicants, the first and second applicants, are seeking as well, or is it only in respect of the relief that the Gender Commission and the other party is seeking?
It's a little difficult to understand from the papers, Justice Theron, but if one looks at the minister's submissions, Mr. Boda will clarify, but if one reads the minister's submissions, they do say no interim relief should be granted in this case. That would mean no interim relief even in relation to the first and second applicants. And the reason for that, as I understand the argument, is because this is a polycentric decision and has many components. So we say that can't be right. That this court has a long series of cases in which it has said it must provide protection in that interim period, and this is appropriate to do that.
Thank you. Thank you, Mr. Rajapatla. Thank you, Justice Matlanga.
Thank you. Ms. Rajapatla, you started by saying that this case is about family and about recognizing and understanding different and changing notions of family. I fully agree with you that the issue of discrimination that has been raised needs to be addressed. My concern lies in the following. The Basic Conditions of Employment Act doesn't define who a parent is. The Children's Act does so. And the Children's Act does so in the sense that a parent is someone who was married to the mother of the child or lived with her at the time of birth, or someone who has contributed to the maintenance and the expenses associated with the child. So the Children's Act, and I think our law has moved away from the notion of parenting being purely a question of biology, but rather a question of relationship. And one must be careful then that if this court in confirmation confirms absent a definition of who a parent is, it would have the unintended consequence that someone who has no connection with the child would be entitled to claim the right that you say Section 25 denies. And I think that would be untenable if someone was purely a biological parent and who then was entitled to, and we can leave the maths out, but at least 50% of the leave entitlement. And that could work to the detriment of the mother, because the biological father would say, well, I'm entitled to at the very least 50%, whether it's 50% of 4 months or 50% of 4 months less 6 weeks. And so I'm not sure what you're thinking about that is, but my sense is that the Children's Act seems to create a carefully carved out place for defining this relationship between parent and child. And we need to be careful that we don't undo that. That brings me simply to my question then. Do you think that, given the need to examine that carefully and how that will play itself out in this Act, that may well be left to Parliament to determine properly, and perhaps that would sort of stand in the way of interim relief that may well undo some of the gains that we've made? I hope you understand where I'm coming from, because in the context of our society, the idea of a biological parent only and not a parent in every other respect is quite rife. I mean, we can take notice of that. I had the opportunity to deal with this in a matter some time ago where I found that a parent was not a parent for the purpose of the Interstate Succession Act, simply on the basis of biology. So what would you say to that? And in particular, my suggestion that perhaps it's best left to Parliament, given the very issue of parenthood.
Justice Colopin, that is something that we contemplated in formulating our interim relief. And that's why we use the language of an employee who has given birth and a partner, a person whose partner has given birth. So we use that language of partner to try and avoid a situation where, let me call them a third party who has contributed biologically to the birth of the child.
You can call them a sperm carrier.
A sperm donor, effectively, but who's not really playing any role or maintaining the child, anything like that. We use the language of partner and person who has given birth to address that concern. When I taught this...
Sorry, could I just ask, in that sense, would such a claimant then have to satisfy the jurisdictional requirement then of showing that they are a partner?
Perhaps, and that does raise the question of whether a definition is then required in that reading in of what a partner means. But I would suspect that, I'm trying to think, the Children's Act, you're right, defines the term parent quite broadly, but in different contexts, but does limit it to biological connection or adoption. I would submit that if you were to accept our formulation, that in terms of the woman, it's fine. She's a woman that's given birth. In terms of the partner, we'd have to put in a definition of partner to address your concern, Justice Colopin. And I would
maybe
imagine
something you can think about and come back to us in reply.
Yes, and I would imagine that would have something about similar to the language that this court has used in relation to a committed long-term relationship, for example. It's not difficult to do. It can be done, and we will certainly give it some thought and provide some language in our reply.
Okay, thank you.
I then raise a question, Ms. Raja Bandler, really following upon perhaps what my colleague Justice Colopin has just raised. Do we need to concern ourselves with the possibility of disagreement between the mother and the partner as to who should take the leave? Of course, I don't know what the definition of partner is that you might eventually come up with, but I suppose it can't be as limited. We can't always assume happy families.
Yes.
Does there then need to be a default provision that if I think yours is one or the other can take the whole 4 months. does one need to have a default position that if the parents can't, or sorry, if the mother and partner can't agree on who takes the 4 months, the default must be that the mother can take it? I'm not sure that that entirely addresses discrimination. You might, at least formally, it doesn't. But there's got to be some tie break.
Yes, Justice Rogers, it doesn't address discrimination, and it may in fact perpetuate certain societal problems here, but it does make sense that if one has to consider that there may be a disagreement, that there is a breaking mechanism, and that may well be most appropriate to say that if the parties can't agree. Although what I'm thinking is how would we ascertain agreement in that situation? So what would probably work is that when you apply for UIF, that on the form, and I don't have the form in front of me, so I don't know, but on the form you'd perhaps have to indicate that you have both agreed to this, and in the event that there's not agreement, that the mother is entitled to the 4 months. I think that would work. It doesn't fix all of our discrimination concerns, but it certainly would work from a practical perspective. But I'd like to give that a bit of thought and perhaps try and deal with it in my reply, because I think it is something that warrants a little bit of thinking.
And then can I ask, is there anything inherently objectionable if one wants to limit the total amount of leave to 4 months or 4 months and 10 days? To say that if the mother does not take more than 6 weeks leave, then the father or the partner's maximum entitlement is 4 months minus 6 weeks. I mean, is that problematic for you?
Not for my...
Because that would, at least on a temporary basis, probably remove the fiscal effects.
Yes, from my client's perspective, that is not problematic. It will be problematic, I think, from the other applicant's perspective, but not mine.
Thank you.
Ms. Rajapatlenda, the difficulties, or rather the difficulties raised with you by my colleagues, do they not point to perhaps the best remedy being just to suspend and say nothing more? Because there are so many imponderables.
Justice Madlanga, I would submit not. I think that an interim reading in has to be crafted to give a just and equitable result. That result is not always going to be perfect. And in a case like this, it's not going to be watertight. It may well be that even when government ultimately legislates however it wishes to do so, that this matter is going to find its way before this court again for exactly these reasons that we're debating. But this court has to protect, in the meantime, if you find an unconstitutionality, you have to provide some protection for that for those affected by the unconstitutionality, and not allow an ongoing violation, as this court has said in Bay. So I would submit that to simply make a finding of unconstitutionality without any protection in the interim would really do a great harm to those involved, and would also, one must bear in mind that if one does that, there is no obligation on the legislature to hurry this process up. There's no obligation on the legislature to really take this as seriously as it warrants to be taken. So I would submit that this court must make some order. It will not be perfect, but it will, as long as it provides it fixes the constitutional problem, it will be sufficient. And really government must then look at how to fix the administrative problems to bring it in line with the court order. That would be my submission. Yeah, I think that's...
Thank you very much. Any other questions, colleagues? Thank you very much, Ms. Rajapatlenda. Ms. Barnes.
Thank you, Justices.
Have we lost Ms. Barnes? Oh, yes.
Acting Deputy Chief Justice, I appear to be having a difficulty with my screen. I wonder if I could perhaps ask the court's indulgence for just a couple of minutes in an attempt to sort it out.
Maybe the best, just get off a video and argue. I don't think colleagues will insist on seeing you. And we will take the tea break exactly at 15:15, but please start.
All right, all right. Thank you, Acting Deputy Chief Justice. I will proceed. I am visible to myself at any rate, but only in a small corner, which is a little disconcerting. I don't know if the rest.
No, you are fully
justices,
visible.
are you?
You are
Am
fully
I?
visible.
All right. Well, that's a relief. Thank you very much.
Thank you.
Thank you, Justices. In my oral submissions this morning, I propose to just address 3 topics. The first topic pertains to what the High Court ordered in this matter. And here, while we are in agreement with the submissions made by our learned colleague for the first and second applicants, we submit that the High Court correctly went 2 steps further. The first further step that the High Court took was that it ruled that the impugned provisions of the Basic Conditions of Employment Act discriminated unfairly not just between biological mothers and biological fathers, but also between biological mothers and other kinds of mothers. And then the second step, the second further step that the High Court took vis-a-vis the relief that's sought by the first and second applicants, was that it said it was not just the impugned provisions of the Basic Conditions of Employment Act that felt to be declared invalid and unconstitutional. It was also the corresponding provisions of the Unemployment Insurance Fund Act. And so the High Court took those 2 additional steps, which encompassed the relief sought by the first and second applicants, but went further. And that is to be found in the first paragraph of the order that the High Court gave. And it is that order we submit that ought to be confirmed by this court. So that is the first topic that I will address. To introduce then the second topic that I will deal with, this pertains to the CGE's application for leave to appeal. And that is our application for leave to appeal against paragraph 29 of the High Court judgment, where the High Court found that the 2-year age cap on parental leave for adopted children is not unfairly discriminatory or otherwise unconstitutional. And here we submit, Justices, in a nutshell, that where the High Court erred here is that it cut down the purpose and the scope of parental leave to nurturing. And I'll demonstrate this in a little bit more detail in due course. But it cut down the scope. It limited it to nurturing, and not just to nurturing, but to nurturing only in the early stages of the child's life. Now, we submit that this cutting down, this truncation by the High Court was unjustified, particularly in light of the uncontested expert evidence that was before the High Court. And I will deal with that expert evidence a little later on in my address. But we submit, Justices, that quite apart from that expert evidence, common sense and reason dictate that parental leave exists not just for the purpose of nurturing, but also, crucially and necessarily, for the purpose of bonding. Now, of course, for biological children, bonding with their parents takes place post-birth. However, for adopted children, precisely because they are adopted, bonding with their parents takes place when they enter their new family at whatever age that may be. And so we submit that once it is appreciated that the purpose of parental leave is not limited to nurturing, but necessarily extends to and embraces bonding, then the unfairly discriminatory nature and effect of this cap, this 2-year cap, is immediately evident. So that's the second topic that I'll address. And then the third topic relates to the relief, the just and equitable relief, which we submit ought to be granted in this matter. And what we submit in this regard is that we effectively endorse the High Court remedy, interim remedy that was crafted, with two relatively minor, but we submit important alterations. But we submit that neither of those should be contentious. Those are firstly, the fact that the High Court, and possibly inadvertently, reduced the overall parental leave that is available to two employed biological parents by 10 days. Now, we submit that that 10 days should go back into the pot as far as that category of parents is concerned. And then in terms of the second alteration that we seek, this relates to the point at which notice of the commencement of parental leave should be given. And here the High Court said that this should happen 4 weeks prior to the birth, and we submit that this should in fact be, as the current Act reflects, 4 weeks prior to the commencement of the parental leave. That is, of course, necessary in order to cater for adoptive parents and surrogacy commissioning parents who would not be in a position to give the notice 4 months, 4 weeks prior to the birth. So those are the two minor, but we submit important alterations to the High Court remedy that we seek. And so in addition to that, of course, if our application for leave to appeal is successful and our appeal is granted, then we would also seek the severance of the necessary words in section 25B1 of the Basic Conditions of Employment Act in order to remove the 2-year age gap. Now, before I proceed to unpack in a little more detail each of those three topics, I'd like to address the court in relation to the minister's actions in these proceedings. And the CGE is concerned and wishes to record that concern. The CGE has a disquiet in relation to the minister's actions that it requires to be placed on record. And the CGE's disquiet is twofold. First, the minister has simply ignored the rules.
Just on that first point, it is 15:15 and we must adjourn at this point. Ms. Pero, please make your announcement and we'll resume. We will resume at 11:30.
Thank you, Acting Deputy Chief Justice.
Court will adjourn until 11:30. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 11:30. Should you exit, you may use the same link to rejoin the hearing.
Thank you.
As it pleases court.
Ms. Sparrow, are all counsel online?
Yes, Acting Deputy Chief Justice Madlanga, all counsel are online.
Thank you. And what about justices?
All justices are also online, Acting Deputy Chief Justice Madlanga.
Thank you very much. Ms. Barnes?
Thank you, Acting Deputy Chief Justice. Before the break, I had indicated that the CGE has a sense of concern and disquiet at the Minister's actions in this matter, and that disquiet is twofold. In the first case, we submit that the Minister has here simply ignored the rules. A notice to abide was filed by the Minister as far back as the 23rd of November last year. Thereafter, in January and March this year, directives were issued by this court inviting written submissions from all the parties, including the respondent. None were filed. Then on the 8th of October 2024, 3 weeks before the hearing date, the Minister filed submissions. It filed an application for condonation, which is, as we have pointed out in our opposing affidavit, overwhelmingly hearsay. And its application for condonation fails to offer an adequate, let alone a compelling explanation for the delay. In fact, the explanation, as far as we can understand it, appears to be that the Minister was waiting for this court to invite it to make a particular submissions on specific points, and had briefed counsel on standby to be on standby for this purpose. Now, this is, of course, not how things work. And we submit with respect that this is not a credible explanation for the Minister's actions. And as we've stated in our opposing affidavit, we submit that this is an attempt to retrofit an explanation for the delay. So in sum, as far as the condonation application is concerned, we submit that it constitutes unacceptable hearsay and fails to provide an adequate explanation for the delay. But the second respect in which the Commission for Gender Equality is disquieted is perhaps a more fundamental one. And this is that the Minister's submissions are deceptive. And we've used the word duplicitous in our answering affidavit. That's a strong averment. We've made that after serious and anxious consideration. We do not make such an averment lightly. But we say this because the Minister claims to be abiding the decision of this court, and it claims that it is making submissions merely to assist the court. But this is not correct. The Minister is in fact opposing all the relief sought by the applicants. It is opposing the CGE's appeal in respect of the 2-year age cap, and it is also opposing the grant of any interim relief. And here, bizarrely and paradoxically, the Minister says on the one hand that it endorses the High Court's finding of unfair discrimination in respect of the provisions, but then on the other hand it says that the unfair discrimination causes no harm, apparently because everybody gets something in terms of the current parental leave regime, and so there's no need for interim relief. The unfair discrimination that has been established is, of course, harm. And without interim relief, we submit and we agree with the submissions made by our colleague for the first and second applicants here. Without interim relief, it won't be corrected. And that we submit this court can't allow to happen. So really, the deep and fundamental source of the CGE's disquiet here is that the Minister has not truly come here to assist the court by explaining why it abides the decision. Instead, it has come, in fact, to oppose the appeal through the back door and under false pretenses. And we take exception to that, and we submit that conduct should be met with an appropriate level of opprobrium by this court. Turning then to my first topic, which is the order granted by the High Court and its inclusion therein of the discrimination vis-a-vis biological mothers and mothers that are not biological mothers. Now, one sees here from the High Court judgment that it concluded in relation to this discrimination that this was a violation of Section 9(3) of the Constitution. So unfair discrimination that could not be justified. But when one has regard to the judgment, it also it makes a finding that there is in fact no rational justification for this differentiation. And one sees that if one goes to the judgment, it's in volume 16 of the record, at page 1109, paragraph 24. And there, the High Court said the following: axiomatically, during the 6 weeks after birth, during which a birth mother may not work except under certain prescribed conditions, and during which she is recovering physically, she is nevertheless nurturing her child in parallel. Why dock 6 weeks off the period available to commissioning and adoptive mothers because they did not experience physical childbirth? What impelling rationale could inform the need for the distinction to be made? No honourable explanation comes to mind, and no legitimate governmental objective is discernible. Now, we submit that that's correct. There is, in the case before you, no rational justification for the differentiation between biological mothers and other mothers. And there is therefore in our submission a violation of Section 9(1). And we submit that on that basis alone, the violation of the Constitutional Equality Clause can be confirmed. Alternatively, in the event that there is some basis to say that there is a rational rational justification for the differentiation, then we submit that it is in any event unfair discrimination, as was found by the High Court. This is because the discrimination is unjustified. And we know that, and my learned colleague for the first and second applicants dealt with this, so I won't deal with it in any detail, but essentially the only justification that was put before the High Court for this differentiation was in relation to the physiological aspect of childbearing. That was it. That biological mothers should be treated differently from other mothers for that reason. And we know that that cannot stand because the Act makes specific provision for the physiological aspects and deals separately with those. And so absent that, no justification whatsoever was put up for the differentiation between these categories. And so whether in terms of 9(1) or in terms of 9(3), that discrimination in its entirety in relation to biological mothers and fathers and in relation to biological mothers and other mothers violates the Constitutional Equality Clause. And that finding of the High Court we submit ought to be confirmed. Also, the High Court's finding that it's not only the provisions of the Basic Conditions of Employment Act, but also the corresponding provisions of the Unemployment Insurance Fund Act stand to be declared invalid and unconstitutional. That too, we submit ought to be confirmed by this court. Let me turn then, Justices, if I may, to my second topic. And this is the CGE's application for leave to appeal the High Court's finding in relation to the 2-year age cap. Now, the High Court deals with this at paragraph 29 of the judgment. And this we find in the record volume 16 at page 1112. And let's begin at the end of the paragraph where the High Court concludes on this topic as follows. Accordingly, in my view, the 2-year cap is not out of kilter with the scope of the intended benefit and does not trigger a cogent complaint of unfair discrimination. So the finding is that the cap is not out of kilter with the scope of the benefit. Now, what is the scope of the benefit? We look according to the High Court. We look at the judgment and we find that the High Court deals with that at paragraph 18 of the judgment, where it says that the proper location of the policy choices evident in the Basic Conditions of Employment Act is in respect of child nurture. And then the judge says not merely a birth mother's experience of pregnancy and childbirth per se, but child nurture. Right? So that's the scope identified by the High Court. We see this reiterated in paragraph 29, where the High Court says, can it, however, be said that an employment benefit aimed only at the nurture of an adopted toddler is unfair discrimination? And then again, in the same paragraph, the High Court says, the guaranteed leave is intended to be only for early childcare. So what one sees then is that the purpose and the scope of the parental leave provisions are limited to nurturing, and to nurturing at the early stages of the child's life only. Now, of course, nurture means to care and protect rather, and that is a key purpose of parental leave. But what the High Court leaves out of account in our respectful submission is another crucial component of what parental leave is for, and that is for bonding. Bonding means the establishment of a relationship with somebody, and in this case, a child. Now, in the High Court, the Commission for Gender Equality put up 2 expert affidavits. The first was by Ms. Nicola Kraus. Ms. Kraus is a psychologist, and she has a doctorate. She has 11 years of clinical experience in the fields of attachment and parental and infant mental health. At the time of deposing to her affidavit, she was program manager at Ubulele Educational and Psychotherapy Trust. Second affidavit by an expert that the CGE put up was that of Ms. Sue Kravitz. Ms. Kravitz is a social worker with a speciality in adoption, and she is the founder and executive director of Impilo, Child Protection and Adoption Services. Now, both these experts opined as follows. 1, adoptive parents ought to receive the same amount of parental leave as biological parents. And 2, restricting parental leave for adoptive parents who adopt a child, to adoptive parents who adopt a child under 2 years of age is irrational. Both of these experts stated that a fundamental purpose of parental leave is bonding. And if I might take you briefly to Ms. Kraus's affidavit, which appears at volume 10 of the record, at page 727. There, from paragraph 11, Ms. Kraus deals with the importance of infant and parental bonding. And she says the following: the development of a secure attachment is associated with various short and long-term benefits for children, parents, and the parental relationship. And she then goes on to set out on page 728 the positive attributes that result from bonding and attachment. And then she goes on at page 728 to say, conversely, the consequences for the child and parent when inadequate parental bonding takes place, and she then sets those out. So I won't read through them, but it's evident that bonding, successful bonding between parent and child are essential in terms of the child's healthy development. Now, importantly, on page 729, Ms. Kraus states that similar principles are applicable in the first phase, few months in brackets, in respect of families whose child of any age is placed in the family through adoption. So the need for bonding and the consequences of inadequate bonding are identical, whether one is dealing with a biological child or whether one is dealing with an adopted child. In relation to the affidavit of Ms. Kravitz, she makes similar points with regards to attachment, and then also makes the following important points. And therefore, she says, adoptive parents and adopted children arguably need more focused time in forming a bond and attachment, which does not biologically exist. Then 2, older children require more time as a result of the increased risk of an unsuccessful adoption. And then Ms. Kravitz makes the following very important points in the context of this case. She says the fact that the 2-year age cap, which we currently see in our legislation, is irrational and not in the best interests of the child for 2 reasons. 1, it means that it is less likely that the adoption will be successful. And 2, it discourages people from adopting children over 2 and therefore results in less children being adopted overall. So we would submit that once it is appreciated that bonding is an integral part of the purpose of parental leave, then we say the rights violation wrought by the 2-year age cap is immediately and starkly apparent. Because that age cap differentiates without rational justification between parents who adopt a child over 2 vis-a-vis all other parents. It discriminates in respect of children who are adopted over 2 vis-a-vis children adopted under 2, as well as other children. And so we submit that it's a violation of Section 9(1) of the Constitution. And if one needs to go that far, a violation of Section 9(3) of the Constitution. We submit that the cap also violates the rights of the child in terms of Section 28 of the Constitution. And this was indeed the uncontested evidence of the experts in the High Court, and that this cap was not in the best interests of the child. And so we submit in those circumstances that the cap cannot stand. It ought to be declared invalid and unconstitutional. And we set out the relief that we seek in that regard in our notice of motion, in our application for leave to appeal at volume 16, page 1145, at paragraph 3.1. I think I am probably coming towards the end of my time, Deputy Acting Chief Justice. I had in mind to address a remedy briefly, but as I indicated in my introduction, we really endorse the High Court's interim relief, subject to our 2 minor alterations in relation to the 10 days and the point at which notice of commencement of the leave should be given. And then, of course, in addition to that, we would seek the severance of the necessary words in relation to Section 25B1 of the Basic Conditions of Employment Act in order to remove the 2-year age cap. Perhaps I can leave it there and take questions. Thank you.
Thank you very much, Ms. Barnes. Colleagues? It looks like there are no questions for you. Thank you very much, Ms. Barnes. Ms.
I've got a question. I was on mute. I was on mute, Acting Deputy Chief Justice.
Thank you.
I was on mute. I'm sorry about that.
No problem. Yes, Justice Chick.
Yes. On the cap, is it not a fact that and perhaps I'm confusing myself here, but I thought that birth mothers would then leave their young ones at 10 at 4 months, the maximum. Am I correct in that thinking? In the
Just-
sense that their leave would be not more than 10, than 4 months.
4 months, yes, yes.
Yes. And even though it is not termed as a cap, but the point is they would then have only 4 months or less in order to bond with their young ones.
Yeah. So that's at the point of the introduction of the child into the family. So which happens
Yes.
with adoption later than birth, and by virtue of the very nature of adoption. So it's at the point at which the child enters the family that there needs to be a bonding, an attachment that takes place between the child and the parents.
Yes,
as
I'm still asking you on the birth, because I want to make sure that I understand. So I'm asking you about the birth mother and the child, that they would only get an opportunity for 4 months at the most, in order to be nurtured and in order for the bonding to take place.
Well, they would be entitled to take leave for that period and have their jobs protected in order to focus on the nurturing and bonding in respect of their new child during that 4 months.
Yes, but the Act as it is, it gives them only 2 months.
I beg your pardon?
I'm saying that the Act as it is now, it gives them 4 months.
Yes, in respect of birth mothers.
Yes, and then in respect of adoptive parents, the Act only protects children who are under the age of 2 years.
It only affords parental leave to parents who adopt a child under 2.
Yes. Let's just focus on the children, because this is where I'd like some clarification and perhaps assistance from you. So I would have thought that birth children or children born of their birth mothers would only get fewer months in order to bond with their parents, whereas adoptive children get more than that. Am I wrong?
I think that may be I think that is possibly a policy consideration that the High Court alluded to. Our case is simply that you cannot leave a whole category of children out of account and provide no parental leave for them whatsoever just because they are adopted over the age of 2. So what the current regime does is it deprives them of any parental leave whatsoever. And so that's a violation of their parents' rights and of their rights vis-a-vis all other children who get parental leave if they're under the age of 2, whether adopted or not. So that's really our complaint. There's a lacuna in the law as it currently stands, and it's discriminatory because it deprives an entire category of children of parental leave. I don't know if that answers your question, Justice Cheeky.
No, it does to a certain extent, but I'm worried about whether there's discrimination at all, actually. And having read carefully what the High Court said, yes, there is a cap, and yes, there are children who have been taken out, the older children and all of that. But when I compared the fact that children born of this kind of relationships, it's very difficult to describe these children, but in a partnership, you'd find that they only have 4 months in order to have that bonding. And adoptive parents have a right up to 2 years.
There was an interruption there, Justice Cheeky.
And I thought that adopted children have got up to 2 years
let me see if I can respond like this. We're asking only for an equivalence, not for anything more. So remember, the adopted, all children, every individual child will only come into a family once, either at birth. Let me see if I can respond like this. There was another interruption there. Every child only comes into a family once, either through birth or through adoption. So now, whether that adoption happens before they're 2 or after they're 2, it only happens once. And it's at that one point of entry into the family that we say there must be an equivalence. So when it's not that the adoptive parents are getting more, they're getting exactly the same as the birth parents get, in that they have 4 months when their child arrives to nurture and bond with the child. I hope that assists.
Okay. No, it does assist. Thank you.
Thank you very much.
Thank you. Yes.
Sorry, Acting Deputy Chief Justice. May I just ask the following question in follow-up of my sister Tiki's? Ms. Barnes, am I correct when I say that children who are adopted, who are older, usually comes from a place of either loss or trauma, and that the adoption of older children are more problematic, and they find it more difficult to adjust to a new family? And that may be the reason why the 2-year age limit does not address the needs of those children and parents. And on that basis, if we act in the best interest of children, as we are obliged to do, that may be the rational connection, not to apply an age limit. Will I be correct to say that?
Yes, if I'm understanding you correctly, Justice Tolmay, it may well be that more needs to be done in terms of other legislation, but at the very least, the adopted children must have the equivalence of what biological children are getting, and the need is significantly greater the older the children get. That is what the experts said, and that evidence was, of course, uncontested.
Thank
I
you.
hope this is, thank you.
Sorry, Ms. Barnes, just a quick one. I mean, on the question of equivalence, if an adopted child is under 2, then equivalence would have been met, correct? It's only when the adoptive child is over 2 that there's a distinction. And the High Court seemed to have reasoned on the basis that what is required in the early months following the birth of a child may well be different than what is required after 2 years. I know in your engagement with my sister, Justice Tolmay, there's the suggestion that, in fact, but I mean, this policy choice, is there any evidence before us in terms of psychological reports or otherwise that would speak to, as it were, generally speaking, the different needs that may arise and that forming the basis for that distinction?
Thank you. Thank you, Justice Colopin. I think that what the expert evidence that is before the court says the following. It says that parental leave is necessary for nurture and for bonding. It's not only nurture. One cannot leave bonding out of account. And as soon as one accepts, and that is, we submit as a matter of common sense and reason also. As soon as one accepts that bonding is part of the equation, then when the child enters the family, however old they are, the same rights ought to be afforded to the children and their parents to allow that bonding to happen. So we submit that the equivalence can only happen pre and post 2 if the same entitlement to time off to accept this new child into your family and form an attachment to the child is given in relation to whichever point the child enters the family.
Sorry, except in respect of an 8-year-old child who gets adopted and who goes off to school. Or even to go. I mean, the need for bonding will still exist, but it'll take place differently. It would take place after school. So to what extent is the basis for distinction at least a valid one, and should the court be insisting on equivalence, notwithstanding what those circumstances may be?
Justice Colopin, thank you. I think that there are different circumstances, absolutely. Older children operate differently and have different needs, but there will always be a need for bonding when a child enters a new home in the context of adoption. And that it takes significant focus. And what the current regime does is it denies that category of children and parents any time whatsoever in order to address bonding. And so what this apart from what may need to happen in the course of through other legislation, perhaps, this legislation treats families unequally in circumstances in which bonding is always required. So that would be our submission.
Okay, thank you. I'll leave it there. Thank you, Ms. Barnes.
So, Ms. Barnes, what for you the cutoff then be, or are you saying there is none?
Our position would be, Acting Deputy Chief Justice, that there isn't a cutoff. The cap is simply removed. That would be our submission.
But how just looking at the example that Justice Colopin gave, how would that work in practical terms for school-going children?
Well, we submit that the school going, if one adopts a 10-year-old,
the parents, the adoptive parents will get to bond with a child when they come back to school. Say it's a child who lives in Soweto and attends school in town, and who will therefore get home around 6 in the early evening, and the parents would have been back from work anyway at that time. So how in practical terms, how would this work? My focus is on the cutoff.
Yes, I think, Acting Deputy Chief Justice Madlanga, that if a 10-year-old child was to come into a family, I think that it would be highly unlikely. I don't want to give evidence here from the bar, but I am. I suspect that I am. That things would just go on as normal. There would likely be a significant period during which that family would spend time together, perhaps taking the child out of school for a period, perhaps going on holiday for a period, during which time they would need to get to know each other.
But this is about leave. So let's foreground that. This is about leave. So what's the point of taking parental leave if the child will be at school all day, coming back home in the early evening at a time when you two would have been coming back from work?
Well, I think our submission is that things wouldn't necessarily go on as usual. There would special arrangements would likely be made in order to take the child into the new family, and parents ought to be afforded that right to make those special arrangements, and the time and the space to make.
Parents won't go to school. The parents won't go to school with the child.
I think I've answered that as best as I can.
Thank you.
Just finally, sorry, Acting Deputy Chief Justice. Ms. Barnes, it may well be that the child would have to take leave, but let me leave that aside. What I'm saying is, should we not be careful as a court that we almost say that unless the legislature is structured in a way to create special time, etc., then there's a real risk. Do we not need to take into account that instinctively parents love and they care and they're concerned for children will find opportunities for bonding in different contexts, under different circumstances, in different ways? At least the lawmaker provides a framework, but beyond that, it's up to the parents, because even someone who takes 4 months leave, there's no guarantee that they'll be bonding. So should we not allow for some leeway in that regard, in terms of what parents themselves bring and the different circumstances under which bonding may take place, rather than be too restrictive? Yeah.
Certainly, I would just, if I may, make two points in response to that. The first is that the expert evidence before this court states that the 2-year age cap discourages parents from adopting. Because if they adopt a 3-year-old or a 4-year-old, let's take the 10-year-old out of the equation for the sake of simplicity in this example. If they adopt a 3-year-old or a 4-year-old or a 5-year-old, they get no parental leave. It's a discouragement. It's been established empirically. And that's what both experts say in their affidavits. And as a consequence of that, there are, of course, many children over 2 who require to be adopted and are not as a direct result of the cap. That's the evidence. So the cap is discouraging adoption, which is a very serious, implication. There are, I think, the expert evidence speaks to the numbers. I think there are 3 million orphans in South Africa currently. So the cap is a problem, and I think all that's being sought is really that an entitlement that is provided to other children be provided to these particular children in order to facilitate bonding. They are, as things currently stand, left entirely out of account. What we should not do is, in the face of this evidence, which is uncontested, do absolutely nothing in relation to this category of children who are left out of account.
Ms. Barnes,
Thank you.
May I ask you this? In determining the discrimination complaint, must we distinguish between what the lawmaker actually intended the purpose of these leave provisions to be, as against what your experts say is desirable? Let us suppose that these leave provisions had actually been introduced by the statement that for the purpose of the nurture of infant children, the following leave provisions apply. To then say, well, for older children, there's a requirement of bonding is not a discrimination complaint, because then the lawmaker has not provided bonding time for anybody. It has provided nurture time. So one might say, for example, that the fact that the lawmaker, albeit discriminatorily, seemed to envisage early nurture to be the sole responsibility of the mother, nevertheless, the fact that it was given to the mother and not to the father suggests an emphasis on nurture, because presumably the lawmaker wasn't saying, well, fathers shouldn't bond with their infant children, but there was no special provision for that. The High Court's remedy, which you essentially support, which involves sharing it and brings down the 4 months to 2 months, I presume, well, yes, the sharing regime would still be, there'd be a 4-month nurture period with, say, the mother taking it for 2 months and the father taking it for 2 months. But that would be entirely arbitrary if one was saying that the purpose was bonding, because you can't say, well, you need 4 months for bonding. Oh, but if you share it, then you only need 2 months for bonding. Is there anything to suggest that the purpose of these provisions went beyond nurture? And is there anything to suggest that 4 months is sufficient for bonding in any environment? Because if as a matter of interpretation, we find that the purpose was nurture of infant children, would you then accept that your complaint can't be one of discrimination? Your complaint then is that the lawmaker for all children should have provided leave time for bonding, and no children have been provided with it.
Thank you, Justice Rogers. I think the answer to that is that there's no suggestion that as the legislation currently stands, that the purpose is limited to nurture. That simply doesn't follow from the legislation as it currently stands. So
are you attributing to the lawmaker the law as it stands? Are you then attributing to the lawmaker a desire that there should just be bonding between a mother and the infant and not also with the father? Because that would follow from your submission.
No, I think that, let me try and answer. I think that as a matter of common sense and reason, the purpose of parental leave is both nurture and bonding. And one doesn't see anything in the legislation which compels an or even suggests with respect an interpretation that the purpose is limited to nurture only. That's what the High Court found, but we say that the High Court erred. There wasn't a basis to interpret the provisions in that fashion. And so that being said, and having regard to the evidence that is before the court, which is about what parental leave is for, ordinarily, and in common sense terms, we submit that the provisions must be interpreted accordingly. I hope that answers the question.
If one's, can you really say that there's nothing to suggest a purpose confined to nurture when the law as it stands gives the parental leave only to the mother, and where in the case of adopted children, it confines it to very young children? Doesn't that strongly suggest that that is the purpose? Otherwise, on that approach, the lawmaker would be, if the lawmaker had bonding in mind, why would they exclude people over the children, adopted children over the age of 2? Why would they not give an equivalent amount of leave to the father?
Well, we submit that the reason they didn't arises out of the patriarchal assumptions that underpin the legislative regime currently. So it's all about mothers and biological mothers, but that doesn't exclude bonding, which is something that must take place between birth mothers and biological mothers also, in order for the healthy development of the child. So we submit with respect that there isn't, the sections don't fall to be interpreted to restrict the purpose to nurture, as the High Court found. The fact that there's a focus on the biological mother seems to us to simply arise out of the fact that this has historically been the domain of the mother. And so it's the birth mother that gets the leave, and the bonding and the nurture is the domain of the birth mother. But so the uneven burdens of childcare that are reflected in the legislation don't seem to us to speak to the absence of a concern with bonding, but rather a focus on the fact that it's the job of the biological mother to do it all.
Thank you.
Thank you, Justice Rogers.
Ms. Barnes, it looks like that's the end of the questions for you. Thank you very much. Ms. Letzler?
Thank you very much, Justice.
Thank you, Acting Deputy Chief Justice. I think my camera was switched off by someone at your court. But I'll start so long while we wait for my face to show again. Having listened to the aspects raised and the questions raised by the court per se, I'm going to truncate my argument to deal with those aspects that are specifically applicable to Zonke and that was raised in the questions asked. I would like to start by saying that the discrimination aspect, as we've seen, is not in dispute between even any of the parties, and as such, of course, Zonke aligns it with that aspect. And for the confirmation of the discrimination aspect, in that I might just maybe add to Ms. Barnes's argument to say that the fact that adoptive children after 2 were excluded from the legislation is per se discriminatory, so that one may look at it as the fact that they were left out as in itself to be a discrimination against them. Then in terms of the reading in aspect is where I think I would like to pose further argument to assist the court in understanding what we as Zonke sees how a reading in should take place, and that we agree with Ms. Raja Padlinda in this aspect that it is essential to have a reading in at this stage. Firstly, I think when one gets to the adoptive leave prospect, that one must maybe look at it as a parental leave period, and rather as a period that needs to be for a specific age of a child. So that one deals with adopted leave, you say there's a parental leave allocated to adoptive parents, and that adoptive parents can structure that as they wish. If one then looks at the aspect of, say, for instance, an 8-year-old child that has to go to school, then such a parent can say, for instance, take leave in the afternoon or whenever it suits them. But that parental leave, when it comes to adoptive or surrogacy parents, are then structured in a way where they place leave like you would for annual leave. You have to apply for it, and it is granted according to the amount of days or months leave you have. That might be an easier way to look at it rather than arguing the age of the adoptive or surrogacy arrangement. When one then looks at biological parents, to exclude a father from that first 6-week period where they currently, as the law stands, only have 10 days, and to say now the mother has to be home alone, not only does she not have the father anymore for those 10 days to help her, but she's completely alone for 6 weeks, having to cope with recovery as well as taking care of the newborn by herself. And that is untenable. And that is where Zonke is coming from in our argument that parents should have equality of leave time. I understand fully the arguments in terms of the fiscus and the complications that they will have in implementing these provisions, and that we can't have policy considerations or change policy or legislation in this court. However, if one, as a reading in, looks as an essential 6-week period for both parents, and I know that is not on the papers, but I'm answering that in accordance with the questions and the concerns that were raised.
Ms. Lesler, I'll add a minute to your time. Don't you want to switch your video on, please?
We are trying very hard, Acting Deputy Chief Justice.
Continue then. Continue.
Thank you. I just didn't want to delay the court unnecessarily by not continuing.
No, continue by all means, no problem.
Thank you very much. If one then looks at the shared 4-month period and you say, okay, we accept that there's a 6-week period that is medically necessary, and we look at that as a postnatal period, which originally before the notice of motion was amended, which is not before this court, read as a perinatal period. So if one looks at a postnatal period for biological parents of 6 weeks joined together, and one then says in the reading in the rest of the 4 months can then be shared, then that is a more reasonable interim relief than simply saying both parents now need to share the 4 months and one parent will at all times be home alone. From a bonding and recovery prospect, we then at least give both parents the opportunity to be at home together for that 6-week period while the mother is recovering. Then either one of those parents can then choose to go back to work. It doesn't change Zonke's position that we believe that both parents should be at home for a period of 4 months or whichever equivalent eventually the legislator decides on. But I understand the difficulties this court has in accepting it as it currently is argued on the papers. And that's why we provided an alternative in our notice of motion to a 4+4, which we ultimately seek and which we will lobby for when it comes to the time. But for now, in terms of, if I may then just answer some of the other questions, there was a question about if both parents now take time off for 4 months each, what happens to, and they now have to regulate that aspect with the different employers. How does this impact on the company now having to employ somebody additional to do this? With all due respect, Acting Deputy Chief Justice and the other Chief Justice and the other justices, this was not something that I would think was raised when POPIA was implemented or when PIA was extended or when risk to compliance and governance legislation was extended. Every company now has to have a risk and compliance person to work in that department to deal with those aspects. So why should we then concern ourselves with somebody having to now deal specifically with leave aspects when it comes to parents wanting to take parental leave? There's already an HR department dealing with parental leave. As it relates to the shared period and the bonding period, and the aspect, I fully agree with my learned friend, Ms. Barnes, that it is not just bonding, but parents bonding also over the birth of a child or over a new child entering the home. And that's why it's necessary for parents to be at home together. If we simply replace the father with the mother, as it currently stands in the reading in, we have the mom alone and the dad coming in after 6 weeks, whereas he has now only seen the baby after work every day, and he now has to take over from the mom. Or he has to take leave for those 6 weeks of his annual leave to support the mother. So in that respect alone, it is discriminatory, and both parents should be able to assist with a newborn child in that respect. If I might then just have a look at my notes, I see I still don't have a face. I apologize for that. In terms of the question raised again in terms of the fiscus and how the fiscus can't possibly make provision for that now, and the concerns raised by both my learned friends regarding the fact that there has to be a reading in and an interim provision to give impetus to the ministers changing the legislation. If this court is inclined not to consider an interim relief because of such budgetary concerns, the next budget is not long off, I would submit. If one is to take into consideration that you only want to make these provisions viable for the department once they have provided for it, then that period is February next year. And we don't have to say that we're going to suspend it forever and a day until the legislation is finalised before we actually implement interim provisions until the law is finalised. If I may, I would just like to finish with an analogy before the guns come out with the questions by stating that, and I'm going to use what I would submit is an analogy of an everyday family. Mom is self-employed. Mom and dad decide to start a family. Mom does not qualify for maternity. Dad qualifies for 10 days. Mom and dad struggle to cope financially due to mom having no income. 15 months later, mom and dad are home with a toddler. The toddler climbs over dad to go ask mom for a juice. Mom is working to catch up after she completed her household duties. That is in essence what encompasses the default parent. And because of a lack of bonding from birth between both parents and that child, which a 6-week period in the minimum for each of them would give, we won't have these scenarios in future where the female does 80% of the household work, as is indicated in the various research projects that we've attached. Then in terms of, if I might just add to another question that was asked about societal changes, in paragraph 7.4 of our submissions, we indicate that we understand, Zonke understands that the social construct of religion, patriarchy, and entrenched norms cannot be changed by legislation alone. But without legislation to support their reform efforts, and other organizations like Zonke that seek gender equality, they would continue to fail in their attempts to change behavior if such changes are not supported by national legislation. Yes, we cannot change how moms and dads look at duties in the household, but if there isn't legislation supporting them to at least think of changing the way they view childcare, then it's going to go nowhere. I have no further submissions. Thank you, Chief Justice.
Thank you very much, Ms. Letzler. Colleagues?
Ms. Letzler, can you please assist me with the proposed remedy? What are you saying the proposed remedy should be?
Thank you, Justice Chike. My proposed remedy is that one awards adoptive and surrogacy parents parental leave overall of a 4-month period. In our view, it should be 4 + 4, but I will leave that up to the court to decide, which they can use whenever the child is adopted, no matter the age of the child. And then in terms of biological parents, that we look at a joint 6-week period as the postnatal period and a shared 4-month period thereafter. Ideally, again, we would like to have a 4 + 4.
I think you're too fast. That's why I didn't get you initially.
I apologize.
Yes, let's just take it slowly.
I apologize, Justice. I will go
So
slower.
you say for adoptive and surrogate parents, you're proposing 4 months leave.
Parental leave, called parental leave, and it is irrelevant what the age of the child is, and that the parents can structure that parental leave in any way suitable to the age of the child.
Okay, all right.
But that's structuring what 4 each, or
We
rather,
would
how should I
wish-
put it? It's basically a total of even though it's concurrent, but basically it's 8 months, but concurrent, running concurrently.
That's what we would wish, Acting Deputy Chief Justice, but as I indicated, we understand the complexities of that.
All right. I just
we-
wanted, I was not interrupting Justice Chickley. I just wanted it to be clear that you are not talking 4 months. Yeah, sorry, my sister, Justice Chickley.
Thank you
for the
very much.
clarification, Acting DCJ.
Thank you, Justice. And then in terms of biological parents, that we look at a concurrent 6-week period for both parents, so that we don't have mom home alone for a period of 6 weeks. Currently, mom has the support of dad for 10 days.
Would the concurrent 6-week period, I want to understand you, mean that each parent takes 6 weeks from work, or is that what you're saying, that each parent would then have to take 6 weeks from work?
Indeed so, Justice. So that both parents would be entitled to the initial 6 weeks period postnatally. And that if we calculate that approximately 60, we don't want to give it 90 days because then we're back to a longer period than what we currently have. But if we look at a period of 60 to 70 days for both parents from Zonke's version, alternatively in the interim measures jointly, so that the parents can decide who stays at home and who goes back to work.
Okay. Thanks, Ms. Metzler. Thanks, Acting DCJ.
Thank you, Justice Chickley.
Acting
Colleagues?
DCJ.
Yes, Justice told me.
Thank you. I've got 2 questions. If we look at parental leave, should we follow the definition as set out in the Children's Act?
Justice Tolmay, I think for me, parental leave is very wide. And I know that, again, we're verging on the aspect of wanting to create legislation or policy considerations, and that's probably something that should be fleshed out in future. For me, parental leave should include grandparents where the parents have gone missing, foster parents, whichever parents are the caregivers. Under social security or social services, those parents are already recognized as being able to get the grant to look after the child. So it's not something that is unknown in our law, but I think it might be taking this argument too far for an interim measure to say we're going to include all parents. That is what we asked for in our papers. We structure it under a wide definition of what parents are, and that a parent is not simply somebody who biologically bore a child, but can go wider, especially in a South African context, than simply that.
Thank you. And the other question is, if we interpret the Act as it presently stands, will it be correct to acknowledge that it comes from a patriarchal perspective? So we cannot just ignore the context, because if we read the sections referring to maternity and how it deals, when we interpret it and decide on a remedy, we can't just look at the Act as it stands. We must look at the context.
Yes, I agree with that, Justice Tolma, and I think I'm sure that if you have sight of the record, you would also have noted that there was mention in the High Court of it being a woman's job to stay at home with the child, which all three as female counsel responded to quite ferociously. So I think, yeah, I felt quite sorry for both Judge Sutherland and my opponent, but I think that what we are trying, and I think all the parties are trying to say it here, is that as the Act currently stands, it's untenable in that it makes the mother responsible for childcare. If we ignore the 6 weeks for a moment and we say, cut off 6 weeks, biologically the mother has to recover. If one takes it further on from the 6 weeks and we say that a father is not entitled to take over from the mother after he had spent 6 weeks bonding and nurturing with that child together with the mother, he's not allowed to take over from that mother to carry on caring for the child, then we are saying it is the mother's job. There was an aspect raised of the difficulty with employment and how it would be structured. But if we look at, and this is raised throughout the papers, that if we are saying that there would be a concern employing men now who can still bear children, that has been the burden of women forever and a day. You know, that we are under the burden of, are you going, and as much as it's unconstitutional to ask somebody, are you going to have a child in the next 2 years? It still happens. In actual fact, I recently viewed, and I'm sorry I'm giving evidence from the bar, you know, but I recently saw a maternity leave policy that does not pay the employee unless they've been there for 2 years. so these things happen out there, and it's to the disadvantage of women all over.
And sorry, just the third, and I promise the last one.
No, feel free, ask your questions, Justice Tolman.
Can one really differentiate between nurturing and bonding? Isn't it an interwoven process of both nurture and bonding? And should we concentrate, or should we try and differentiate between nurturing and bonding? I just thought about it during the previous discourse. How can I differentiate between the two concepts? Can you give any assistance in that regard?
Again, if I have to give evidence from the bar, Justice Tolma, I think that nurturing would probably relate to the period that mothers breastfeed, or that nurturing might be something that was ideally seen as the job of the woman, that a child would be closer to the mother, etc. But I think nurturing and bonding, as I understand from your question, is not something that is only in the domain of the mother, and that should be duly accepted by both parents, and should be the responsibility of both parents. And if if one goes back into the reason why maternity leave was changed from 3 to 4 months, it related, if I recall correctly, to the health period to breastfeed that was lobbied for, that 4 months is the ideal in terms of breastfeeding. But one can express there's lots of other ways. Again, I don't want to give evidence from the bar, but I think both parents are entitled to nurture and bond with that child for at a minimum 6 weeks together, and then thereafter to structure it, if they can't get 4 months each, to structure it in a way that suits them both. Currently, to be at home for 10 days is nothing to help the mother that's just given birth.
Thank you.
Ms. Letzler, if I understand you correctly, what you are proposing in terms of remedy is for both parents. I'm talking about the biological parents, that they should get 6 weeks each. It will take us to about two months, just over 2 months. And then you are saying, is that period, is it going to be taken from the 4 months that is there, or are you saying 6 weeks each and 4 months each?
I think ideally, Justice McClellan, if you have a look at our papers, we are asking for 4 months each. But in respect of an interim provision and for fear of the interim provision going away completely, we are happy to concede that 4 months each at this juncture may not be possible, but that is 6 weeks each for both parents are tenable, and that the period thereafter can then be shared as an interim provision. So that if one deducts the 6 weeks each from the joint 4-month period, or one says without fail, both are entitled to 6 weeks each, and then what is left is, say, a period of 2 months for each parent, either together or for each parent to share, whichever way the court wants to structure it. Ideally, Zonke would like to say that parents should be at home together for 4 months, including the 6 weeks each. That, as I stated, might be untenable for an interim provision, and that's therefore I'm prepared to enter the alternative to say 6 weeks for each parent at home together, and that whatever is left of the 4-month leave to then be shared. And I think that would be fair, because otherwise we're leaving the mother, as I said earlier on, as it currently stands with the interim relief, we're not even giving her the father for those 10 days. We're giving her 6 weeks by herself because she can't go to work.
Thank you, thank you, ACDC.
I've got a question, Acting DCJ. Just a follow-up, Ms. Letzler. Is prescribing a minimum or paternity leave an economic right at all?
It might not be an economic right, Justice, but it certainly is a constitutional right. And as I indicated earlier on when I read that passage from our submissions, that if one ignores the fact that both parents are entitled to nurture and bond with a child, then one is discriminating. And if one looks at the economics of this, as I indicated, if there is concern with the interim measures being implemented immediately, one can postpone that to the next budget meeting in February, because then provision can be made for it. And it would also allow corporates to get their policies in line with the new provision. So there is an out here if one can't implement it immediately because of concerns with budget and implementation. But then thereafter, the 2 years need to stand, that in which the minister needs to fix the legislation as it currently stands.
I'm asking this question because I'd like you to assist me in differentiating how it is different, for instance, from the right to housing and the right to the other rights that this court has held are economic rights.
I understand. Thank you, Justice Tiki. I think if you look at the Social Security case, sorry, I don't have it right in front of me now. In there, it was indicated that it could not be extended to foreigners due to the fact that it would put an unnecessarily economic burden. And there was also, I think, the Besaidenhout case or the Barkhuizen case, if I remember correctly, one of the two, where it was indicated that economic considerations, these cases are before the court, should, when it's an unnecessary extension or is an extension that places an unnecessary burden on the department, then it should not be considered. If one looks at the affidavit as set out by my learned friend, Ms. Barnes, where she contradicts what the department has said, and if one accepts the department's hearsay to a certain extent, then one can say that there is the possibility to extend this, especially if one looks at my learned friend indicated adoptive parents get something like 0.2% of the current UIF grants. And if one then looks at 91%, according to Ms. Barnes's research, goes towards unemployment fund, and only the rest of it goes to UIF, which is an indication that the UIF or not UIF, my apologies, to maternity leaves, which indicates that the economic burden on the UIF is relatively small in comparison to unemployment, and that we then can't say we are going to prejudice mothers and fathers, simply because the country has such a huge unemployment burden, because the UIF can't cope with the unemployment burden. That I would submit would be grossly unfair.
So your submission is that it's not an economic right.
Yes, it's an all-out right, I would submit. It's a right in the Bill of Rights to not discriminate against a child, which in this case it is. It's discriminating against children more so than just against fathers and mothers, in that it doesn't allow a child for his formative couple of weeks when they're starting to smile, when they're getting their first teeth, or however long it takes the child to do the fun things, not to have both parents at home.
Yes, my question is more related to the fact that UIF would have to pay during that period. I'm aware about the right to the child and to the mother, but as I was reflecting, I reflected on whether it is also, or it also touches on the economy of the country.
I think in my response, Justice, I turn it around by saying, can one use economics as an excuse not to do it? And I would submit not.
But if we were to prescribe to the legislature, would we not be prescribing a minimum regarding economic right?
But that is why we are arguing, Justice, for interim measures, and that we are saying that there should be interim measures, and that if the court is concerned with the economic impact, that these interim measures start running from the next budget, so that provision can be made for it, and everybody has an opportunity to change their legislation or their policies. If one excludes it completely, I fully agree with my learned friends there. This will be in 10 years' time. The young Master van Wyk will have his own children by the time he has the benefit of implementing these policies. So we can't leave it without making interim measures, because legislation simply takes too long to enact, to have public input, to have discussion. And this matter will raise huge public discussions, lots of input from corporates, from everybody that would be unhappy or happy with it, want to make it more or make it less. And therefore, if we don't have an interim measure, it could be a decade before this law is implemented.
Thank you.
Thank you. Ms. Lesler, just a very small matter on characterization. Sonke characterizes its application as a cross appeal. I understand it to be an appeal, not cross, because there's nobody else except for CGE, and you are not countering CGE.
No, we are not.
Nobody else has appealed. So it's, yeah, as I said, small matter, but quite important for purposes of litigating.
Thank you, Deputy Chief Justice. Thank you for pointing that out. It is correct.
Thank you. I don't see any further questions from colleagues. Thank you very much, Ms. Lesler. Mr. Buerda, are you back from prayers? Colleagues, I forgot to tell you at our meeting before we started that Mr. Buerda requested to leave the proceedings to attend prayers, but he said that his junior is in a position to argue. Mr. Langa.
Well, Justice Langa, I am here. I have managed to find, I'm not sure if the court is mindful of taking a lunch adjournment.
We will take a lunch adjournment exactly at 1, Mr. Buerda. It doesn't matter where you are with your argument, yeah.
Okay, so that I've managed to find a most to attend at 1:15, so I'll be okay.
that will be for 45 minutes only. So if you are not back, your junior will continue where you were at 1 o'clock.
No, I would be back comfortably, I'm pretty sure.
Thank you. Thank you very much.
Yes. Thank you, Justices. Justices, this case concerns the foundational rights of the Constitution to equality, dignity, fair labor practices, and the rights of children. It also gives rise to important policy issues and compels the court to make difficult policy choices in the face of varying and sometimes competing interests. The paramount interest is, of course, that of the child. Then there are the interests of the parents as parents and employees, the interest of employers, and the policy interest of the state. There are also fiscal issues pertaining to the impact on scarce state resources. Before we can address the court more fully on these issues, we need first to apply for condemnation for the late delivery of the heads of argument. Without in any way assuming that condemnation is there for the taking, we submit that we have explained the delay in the application for condemnation as best as we can, which is by no means without criticism, and that it would in any event be in the interest of justice to hear the minister. The current minister took office on 3 July 2024. I was briefed on 8 August 2024 and received the documents on 19 August. I called for a consultation on 3 September 2024 to take instructions because I was reading the documents in a vacuum, and only learned at that meeting that the directive for heads had been issued already. I needed again to clarify exactly what my instructions were on, and did so on 30 September 2024 after reading the record. I also tried to take steps to remedy the lack of financial information before the court, which was an obvious problem that emanated from this case, which has not borne, unfortunately not borne any fruits. The rest of what happened is explained in paragraphs 27 to 32 of the affidavit in support of condemnation, and I'm not going to read out what is set out there. The previous minister's decision to abide without delivering any affidavit to explain the stance did not assist the court in any way and gave no indication of what the minister's attitude was to the cross appeal and the issue of relief. The heads of argument delivered on behalf of the current minister, after taking instructions, clarifies the issues the minister seeks to address the court on. There may be a case that the minister has preempted the minister's right to have an audience, but I submit that preemption can be relaxed in the interest of justice. The issues are fundamentally important for the minister's views to be considered. This is especially so as the High Court came up with an order that some of the applicants did not want. The minister must be allowed to address this order. We recognize that we have not applied to cross-appeal or appeal or file an affidavit, but we believe we can contribute to the deliberations of the court and must do so as part of the minister's constitutional duty. This court in ex parte Umar has said that if the government takes the view that it cannot support the legislation, then it ought to have explained to the court the reasons for its attitude and what it considered to be an appropriate order in the circumstances. What complicates the present matter is that the parties have appealed or cross-appealed certain aspects of the High Court and are not in agreement on the issue of relief. This is not in contention. The consequences of this is that in providing an explanation for abiding, the minister must necessarily express a view about the correctness or not of the appeals. Had all parties been in agreement regarding the relief, the position would have been different, but to discharge the minister's obligation and prefer an explanation of the minister's attitude, it was necessary for the minister to offer some views on the appeals. In addition, the minister, as a material party to the court, can offer a perspective about the financial and logistical implications of the court's decision or the High Court's decision and express an informed view of the implications of any interim relief this court grants. In conclusion on the condemnation, we submit that and we sincerely apologize to the court and to all the parties for the extreme inconvenience that the late heads has caused, but we submit that it is in the interest of justice to grant condemnation, and that if any party is prejudiced, they could always be granted leave to make supplementary submissions. I now want to turn to the crucial issues, and I'm going to first deal with the maternity and parental leave provisions in section 25 and 25A and the appropriate relief. I will then go on to deal with leave for adoptive and surrogate parents, and finally the issue of the limitation for leave for adoptive parents for children under 2 years old. So I'm going to deal with it in those three categories. So first, section 25 and 25A. Without legislative protection, scrupulous employers will not allow leave for women who are pregnant, save at the pain of resignation, or they would not allow women to come back to work after maternity leave. That's the background to the granting of statutory protection. The social reality requires one to strike an obvious balance when a woman takes leave or maternity leave or any, in particular, one partner must provide one partner must provide for the family and the other must take care of the child. Both can't stay at home unless they are affluent families. UIF, as a reality, takes a year or more to pay. The BCEA provides minimum guarantees to parties, and the common law and LRA gives parties the space to negotiate more generous arrangements contractually. Section 25 deals specifically with maternity leave and was intentionally designed to affirm the birth mother only, to enable her to balance a productive and reproductive role. It was intentionally enacted to provide 4 months leave for the biological mother only and leaves no room for the non-birthing parent to take such leave. The ILO has a standard of 14 weeks in Convention 183, which stipulates a woman to whom this convention applies shall be entitled to a period of maternity leave of not less than 14 weeks, and the Maternity Protection Recommendation 191 encourages 18 weeks of maternity leave by stipulating that members should endeavor to extend the period of maternity leave referred to in Article 4 of the Convention to at least 18 weeks. This is at Volume 11, Answering Affidavit, paragraph 106. The provision of this section 25 are then complemented by Section 24 in Part D of the UIF Act, which stipulates maternity benefits for the mother on application to the UIF. These benefits are kept. This section for completeness must be read together with Section 181C of the LRA, which expands the definition of dismissal to include the refusal by the employer to allow an employee to return to work after she took maternity leave in terms of any law, collective agreement, or her contract of employment. This Section 2 was designed to protect women. Section 25A, which was introduced later, is in turn designed to provide 10 days leave to the non-birthing parent, such as but not limited to the father. The ILO and international practice recognizes that paternal leave is generally a short period of leave, but this reflects the need for the child to be attended to on the one hand and the family to be provided for on the other, given that the UIF Act provides limited benefits to the parties for this period of leave. Only 5 countries, as far as we can tell, among developed economies, provide paternity leave of more than 2 weeks. The High Court nevertheless found these sections to be unconstitutional, suspended the declaration of invalidity for 2 years and granted interim relief, effectively leaving the decision of how to split the 4 months leave to the parents. In doing so, the High Court made a policy choice which favored a privately agreed leave regime rather than a standardized leave regime that is imposed on the parties. An analysis of these sections make it clear that parental leave, which includes maternity and other leave, paternity leave, if I can use that just as an example, consists of 3 phases. The first phase is the preparatory phase, which is used for before birth to prepare for the child. 4 weeks for the birthing mother unless otherwise agreed or determined by a medical practitioner or midwife. The second phase is the physiological dimension, 6 weeks after the birth, which serves 2 purposes: recovery and child nurturing, including if the mother chooses breastfeeding, and a concurrent 10-day period for the non-birthing parent to assist in this early period. This concurrent period is taken away in the High Court formulation of interim relief. Post 6 weeks and recovery, that's the third period, post 6 weeks and recovery, which is given to the mother to primarily continue nurturing the child. Breastfeeding is a classic example of this. Currently, only the birthing mother enjoys this benefit. Adoptive and surrogate parents get 10 weeks, and this is dealt with separately. In truth, as the High Court said, the child rearing phase commences from the birth of the child to the end of the parental leave, and the section leaves no one else but the birth mother to take such leave to its expiry. It is on this basis that we hold instructions to acknowledge that discrimination does arise. The treatment of different parents is unequal and amounts to unfair discrimination for the reasons found by the High Court. The facts in the case of Mr. and Mrs. van Wyk illustrate this. The section prevented Mr. van Wyk from exercising his choice to nurture their child as the primary caregiver and prevented Mrs. van Wyk from exercising her choice to return to work earlier. The state thus has no difficulty with the order of the High Court declaring these sections unconstitutional, suspending the declaration of invalidity, and affording the state 2 years to rectify the situation. The state, however, has enormous difficulty with the interim order imposing a private consent arrangement. There is a distinction between a finding of unconstitutionality and the discretion to order interim relief. it does not follow automatically that because a section is declared unconstitutional, interim relief must axiomatically follow. Reasons not to grant interim relief include where it is not feasible for a court to do so, or where the decision should be left to Parliament. The present case and the polycentric nature of the decisions, as well as the potential financial consequences that will flow, are indicative that the courts are not well placed to craft feasible and implement interim relief for a scheme as complex as parental leave. I first want to deal with suspending the order. I'm going to be very brief. It appears that everybody is in agreement that the order of the High Court declaring the sections to be unconstitutional should be suspended for Parliament to be given 2 years to rectify that situation. And because there appears to be no differences between the parties on that issue, I'm not going to deal with the issue of suspending the relief and the 2-year period any further. The state is in alignment with that. I'm going to focus my submissions on the interim relief granted by the High Court. The range of relief sought by the applicants and different constructions of the relevant legislative sections illustrates the complexity and value-laden nature of the issues before the court. There is no better illustration than this of why no interim relief should be granted and why correcting these defects ought to be left in the hands of the legislature. As the Van Wyk applicants note, any construction proposed by this court would potentially tie the hands of the legislature, and given the potential financial, social, and policy implications of this decision, this would be undesirable. In particular, the court ought to be mindful that part of making the amended parental leave scheme affordable and feasible in our present context may be for Parliament to reduce the benefit. This is something the High Court noted, but which the applicants are trying to close off. The High Court made a policy choice which favored an agreed leave regime rather than a standardized leave regime which is imposed on the parties by the state. The interim relief on co-parents agreeing to a division of parental leave through a consent arrangement. There are 5 principal difficulties with this consent arrangement order. First, the Van Wyk family dynamic reflected gender equality, where both parents could and did negotiate their rights on equal terms. But this is an exception rather than a norm. It is not always the case that women have equal bargaining power in relationships. In many instances, they do not, and there remains a social expectation for women to be primary caregivers. This is particularly so given the high rates of domestic violence and gender disparities. Many women find themselves in abusive relationships with no personal autonomy. They are isolated and their voices marginalized. They have no bargaining power whatsoever. In these situations, the mother would simply succumb to the father's preferences, even if it is to her prejudice and the prejudice of the children, simply out of fear and self-preservation. But even in non-abusive relationships, unequal power dynamics may force the mother to give in to the father's wishes and result in unequal decision-making. The result of these real power dynamics may not only perpetuate the same regime as in the present legislation, but may lead to agreed consensual arrangements which are even inferior to the present position and thus could prejudice mothers even further. The mother may wish to breastfeed and to remain at home for the full 4 months, but because the father has superior bargaining power, she may decide to sacrifice this and agree to return to work because she may be a higher earner. The importance of this is highlighted at volume 8, page 550. A number of studies have found that once a woman returns to work, they are less likely to begin or continue breastfeeding. Mothers may feel pressured to return to work sooner than they want to, as to enable the father to take leave, or if the father pressurizes her to give more of the leave to him, then this is another scenario which makes it difficult for her. It must be acknowledged that these decisions don't take place in vacuum, but within the contextual reality that in South Africa, gender disparity and power dynamics will likely influence decision. Alternatively, mothers may also be pressured to return to work sooner by the employer on the grounds that the father could take care of the child or that taking the full leave may compromise their career prospects. This may be prejudicial to women. The mother who wishes to breastfeed a child is in addition forced to sacrifice her personal autonomy and subject to what is quintessentially a woman's choice, grounded in her physical and lifestyle needs, to endure influence from a partner competing for leave. Perhaps the solution in the interim period is something like allowing the mother to cede her rights rather than subjecting it to an agreement. Conversely, fathers may face workers work pressure or expectations not to take any parental leave and let the mother take the entire period. There is a further and second difficulty with the consent model. In the absence of agreement, there ought to be some mechanism to decide how leave ought to be apportioned. But the High Court order does not cater for this precisely because catering for such problem will require the court to impose a standardized regime or a default regime. This is best left for Parliament to determine because of the competing interests. For instance, is the best standardized model for sharing parental leave the use it, lose it option, which is punted at volume 6, page 408, perfect parity agreement, or some other via media. Polygamous marriages create a further difficulty with being able to properly negotiate the parental leave arrangements. Thirdly, allowing the parents to decide the matter solely based on what they wish to do denudes consideration of the best interest of the child, as the parents may not always agree to what is in their child's best interest. And the corporate punishment cases are clear examples of this. One glaring omission in the proposed regime is its failure to accommodate for breastfeeding, which the World Health Organization and the South African Department of Health have endorsed as being in the best interest of the child and is a right given protection in section 26 of the BCA.
Mr. Boda,
see, my time is up.
No, your time is not up. But let us take the lunch adjournment now, 45 minutes.
Thank you.
Court will adjourn until 13:45. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone and then rejoin with video and sound when the hearing recommences at 13:45. Should you exit, you may use the same link to rejoin the hearing.
Thanks, Ms. Pero.
You're
Ms. Pero-
muted, acting DCJ.
Thank you. Ms. Pero, are all counsel online?
Yes, Acting Deputy Chief Justice, all counsel are online, and
All right.
we do have all the judges online, but not all their videos on yet.
No problem at all. I want to speak to counsel. Counsel, and also your attorneys, if they can hear. Do you know any person who is joining using Samsung SM-A256E? Do you know any such person?
I don't know anyone, Deputy Chief.
No,
Don't have a-
Deputy Chief Justice.
All right. Then we will not let that person join. If they want to join, then they can call, because we gave our IT person's phone number for people who have problems to contact our IT person. So yeah, we will not let them in. Thank you very much, counsel. Just look. And we have 1 minute to go, but I think we can start if we are all here.
May I proceed?
Yes, Mr. Borden.
Thank you. I was dealing before the break with the problems with the consent arrangement interim order imposed by the High Court, and I dealt with the fact that women don't enjoy equal bargaining power as the first problem. The second problem was that there's no deadlock breaking mechanism in the absence of an agreement. And I was dealing with the third problem, which is to allow the parents to decide the matter solely based on what they wish, to nude considerations of the best interest of the child, as the parties may not always act in the best interest of the child. And I mean, the classic example would be, again, breastfeeding. It may be in the interest of the child to be breastfed properly for the whole term, and the arrangement could negate that particular consideration. The fourth difficulty with the consent arrangement is that employers' interest may be prejudicially affected. Leaving the parents to agree may result in inconsistent leave patterns in the workplace, and inconsistency as between employers, with some having to spend more on training and finding recruitment labor than others. Those that chose parental care over work may be stigmatized for placing work before the needs of their child, and those that chose to bond with their child may be compared to others in the same gender that chose to put work first. There are also challenges for employers where an unclear or flexible leave arrangement can complicate workforce planning and staffing, leading to potential gaps in coverage or productivity. It is not always easy for employers to find replacement labor, particularly for skilled jobs. Time is lost in onboarding and training the new person, and that cost may be unaffordable for small business. Employers may also use their muscle to weigh in on the bargain. It is also unclear how the potential for abuse could be adequately managed through interim relief. As has been noted, we submit that the current regime, in other words, if the court does not grant interim relief and leaves the current regime in place, the current regime does not create substantial harm to parents, as it makes provision for some leave for all categories of parents, except those adopting children older than 2 years old. The failure to provide interim relief does not render parents destitute or helpless. They continue to have access to the more limited parental leave benefits that the UIF has budgeted for and provided under the BCA, and which are not out of kilter with established ILO standards and not in violation of any international instrument. The agreement model is thus fundamentally problematic, and the interim relief is inappropriate. When I now deal with the question of the reading in, which is another proposal put forward by the parties. The decision in Tronak highlights the need for any reading in to result in provisions that authoritatively pass constitutional muster, and it is not apparent from that iterations of the impugned sections of the BCA would indeed represent a version of the BCA that definitely passes constitutional muster. Also, the formulation of the proposed reading in would require guidelines to be created for its implementation, and that is precisely where reading in is not an appropriate remedy. In the present matter, reading in cannot completely, definitively, or clearly cure the constitutional defects in the BCA. The reading in proposed by the Sonke Gender Justice will result in the same problems as it posits an election. It stipulates that an employee who has given birth or whose partner has given birth is entitled to at least 4 weeks consecutive leave. On the formulation of the reading in as proposed, it is not clear which parent decides to take the leave or how they are to decide this and how a conflict between them will be resolved. The formulation also creates inconsistencies between the recovery period and the child nurture period, as is clear from the reading the proposed formulation as a whole. The reading in proposed leaves the section ambiguous. It doesn't articulate how the arrangement should be operationalized, and this leaves it vulnerable to deadlocks between parents who cannot agree. It may perpetuate the problem because of the power dynamics mentioned earlier. The better model we submit is for the court to leave it to the legislature to decide based on policy choices of where to prescribe the correct formula and also to take into account the needs of the child. The minister submits thus that no interim reading is warranted and that the declaration of constitutional invalidity in respect of sections 25(1) and 1 and A are appropriate and sufficient. I now deal with section 25C and D. We hold instructions to submit that the current inconsistency between different parents is unconstitutional. The 10-week leave period in sections 25C and 25D seem to be aligned to the recovery period in section 25(2) and 3 rather than the child nurture period, which is in truth commences from the birth of the child to the end of the leave period. The state has no difficulty with the declaration of constitutional invalidity. However, the interim relief granted by the High Court on this aspect is also problematic because it is subjected to the consent arrangement, and the same criticisms that I've dealt with apply to this as well. Further, there is a demand by the parties to have surrogate parents, adoptive parents, and biological parents treated the same under the parental regime, but one has to recognize the fact of the physical reality of giving birth, which the birth mother will experience and no one else. And this is particularly so in the pre-birth period of 4 weeks and the 10 weeks thereafter. How parental leave should be adjusted to account for other kinds of parents is a matter best left again for the legislature. I then deal with the capping leave for adoptive parents of children under the age of 2. A child is, in terms of the Children's Act, is defined as any person under the age of 18. The needs of a child of 17 years, 11 months is not the same as the needs of a child of 2 years. It is unclear why the leave regime should be aligned to the Children's Act. The state could have done more to explain the purpose of the section. The current law was designed to align adoptive parental leave benefits with those available to biological parents who often receive maternity or paternity leave around the birth of a child. Since biological parental leave typically addresses the early and high developmental needs of infants, similar provisions for adoptive parents of children under 2 who may be viewed as being similarly situated are equitable and rational and do not in any way result in age discrimination, reflecting the age-related needs rather than the type of parental relationship. Natural children over the age of 4 months also need bonding, but they don't have the rights to parents taking time off for this purpose. The beneficiary is determined by the developmental age of the child as a matter of policy. A child of less than 2 years old may still be of breastfeeding age. Their developmental needs are not the same. A policy choice was made on the age to nurture young children. As soon as one accepts that bonding is not part of the equation, then this provision cannot be declared unconstitutional. The 2-year gap was also introduced by the legislature to ensure that benefits are affordable. Expanding the benefit to an uncertain age or without any cap would clearly create financial consequences for the state. I then deal with the last topic, which is financial implications generically. If one looks at all of the proposed amendments to the other sections, that's 25C and D, if one is going to increase the leave for parents who are adopting children and other parents to 4 months, naturally that is going to have financial consequences for the state. If one is going to change section 25(1) by doubling the leave and giving both parents 4 months, it's axiomatic that whatever the state is now paying for maternity benefits or paternity benefits is going to double. We acknowledge that the state has not assisted the court by placing proper expert or actuarial evidence about the financial implications on the UIF fund and given proper data to the court. This is indeed most unfortunate. As I've said, I've tried to do my part to try and rectify the situation without being successful. So our submissions on financial implications are necessarily generic in nature. There is an obvious direct financial impact on the UIF. This is recognized expressly by the High Court in paragraph 38 of the judgment, and it is quite clear that all of the any extension of the benefits will have financial implications. We submit that in the situation that we find ourselves, unfortunate as it is, where the state hasn't placed data before the court, it is best left for the state to interrogate properly the financial consequences of any amendments, and to allow NEDLAC also, because this is labor legislation, which will have to pass through NEDLAC, to examine any financial consequences, not only to the state, but to employers as a result of any consequential amendments. We accordingly submit that interim relief should not be granted, and that, save for that, the rest of the High Court's order should be confirmed. Thank you, Acting Deputy Chief Justice. Those are my submissions.
Thank you, Mr. Boda. Colleagues?
I perhaps just ask Mr. Boda this question. If there is no interim relief and Parliament doesn't enact remedial legislation within 2 years, the effect of the declaration of invalidity will come into operation, which means that nobody, not even biological mothers, will have any rights to maternal leave. Is that so?
Yes.
So is that desirable, or do you say that if Parliament hasn't done something, if the 2 years are, because we've had a number of instances where, for good reason or bad, Parliament hasn't met the two-year deadline. Do you say we need another court case in 2 years' time for an interim arrangement if Parliament has been delinquent?
That may be a possibility. The difficulty with the interim arrangement is, I've already said the consensual arrangement is problematic. The one other interim arrangement that the court could potentially craft is to allow the birth mother to cede her rights in the period after recovery. So if one takes the 4 months, the first 10 weeks are really for the mother to prepare for birth. The first 4 weeks, the second 6 weeks is for the mother to recover. And then we have a balance of 7.23 weeks, which is where the controversy really arises. And I was thinking of the idea of allowing in the interim the mother to cede, to be able to cede her rights, so it's her decision. It's not subjected to an agreement to the father. But that also comes with questions of policy, because the mother, the state may want that not to happen because it may want to further the interest of the child. So the difficulty with interim relief is just to find the right solution to the problem, and the solution is really, I mean, I think that the case, the Van Wyk case, is a really unique circumstance where and I'm not saying it can't happen, as my learned friend said, it happened again, where they found themselves in the unfortunate situation of having to now compromise their wishes. But that may have to endure until 2 years, and if interim relief is not, if no relief is granted, then the parties should come to court then and be allowed to properly debate what sort of model for interim relief there should be, given the circumstance.
Well, I think your colleagues on the other side would say that was the whole purpose of the High Court hearing and then of this hearing. Why should it be, if it is assumed that absent intervention by Parliament, something will have to be done, we can't just have the sections being declared invalid. That presupposes that, for better or for worse, the court will have to intervene. And isn't that what the case has been about up to now? Although there's been some contestation on the adoption provision, I think there's been general consensus that 25 is objectionable. And the question is, how do we deal with it? Why should it be deferred for 2 years?
Because unfortunately,
after all, if
yeah,
Parliament doesn't like, if Parliament finds what has been done objectionable by the court, well, it can move more quickly, I suppose, and enact something sooner. But whatever happens, as long as Parliament plays its part, will only last for 2 years or for longer if Parliament is tardy.
Yes, I accept that, Justice Rogers. I accept all of what you say. It's just about finding the right balance, and without knowing the financial implications for the state, and this is where the state failed. I can't take that further. I don't know whether it's appropriate to grant any sort of interim relief now, or perhaps it should be deferred for a later date. But I can't take it further. I accept what you say.
And just on the detail, what you said might perhaps just work if there was to be an interim remedy. I don't quite understand this idea of the biological mother ceding her rights, because it seems to me that if you are concerned about abuse, unequal power dynamics within a parental relationship, I think the mother could be pressed to cede. It seems to me almost indistinguishable between that and a consensual arrangement.
I agree. It was I was trying to find perhaps some sort of way out of the consensus problem, but it doesn't go away with the session. It doesn't go away with that. Absolutely.
Yep. Miss Letzler, when she was addressing us I think she was asked a question by a member of the court on the difference between nurture and bonding as potential objectives. Are they dual objectives in these provisions, or is it only nurture? And she made reference to there initially being a 3-month maternal leave, and it was increased to 4 months, and that was linked to information about the duration of breastfeeding. Or is that anything that the minister has commented on, or
I haven't particularly received instructions on that, but I know from the ILO conventions and the BCA that breastfeeding is something that is clearly promoted, and so when one looks at the time period for maternity leave, it sort of aligns with international standards. The WHO, there is a report in one of the annexures which says the WHO recommends 6 months of breastfeeding. So it seems to me to be logical that the periods were aligned to ensure that to actually promote breastfeeding. Unfortunately, the state has not put up that as a justification in its papers. That could have been properly articulated and explained to the court. So one is only I can only infer that what my learned friend said is correct. I haven't got any specific information on what informed those amendments. I have not looked at the explanatory memorandums, but that is something we can clearly contribute to if we are allowed some leeway to do that.
You see, I don't doubt that during, assuming the mother takes off 4 months and breastfeeds her child, or doesn't breastfeed her child but takes off 4 months, during that 4 months important bonding will take place between the mother and the child. But if it is aligned to such a thing as a reasonable period for breastfeeding in the privacy of the home, then it might suggest a focus on nurturing, and that that is not because bonding is unimportant, but bonding presumably takes place over a much longer period than 4 months, and fathers can bond in the time that they have available, even if they have to be at work, before they go to work, when they come home from work, and so on. There are ways of bonding. I mean, presumably that's how it has happened up to now.
Yes. No, certainly.
Maybe not optimally. I don't know.
No, I mean, obviously, bonding it can't stop at 4 months. I mean, we all understand that. So that 4 month period does seem to suggest a focus on child nurturing and a promotion for breastfeeding. And some of the ILO reports, the minister has fleshed it out in the answering affidavit. There was an ILO report examining, I think, 175 countries and how they deal with paternity and maternity leave. And even that report said that the paternal leave would encourage breastfeeding, because the father would be there to assist the mother to do other chores in the household while that early stage the father may want to register the birth of a child, and there's all of other things that needs to be done. But the reason for the 10-day period, that initial period, also seems to suggest that what the focus was to promote breastfeeding as a policy. But as I said, it is really unfortunate that this has not been fleshed out in the answering affidavits. It could have been fleshed out and dealt with more clearly. But it seems quite logical to infer that there's limited time periods were there to promote breastfeeding. I can't think of anything else. I mean, there are other nurturing issues, but I can't think of anything else beyond that. Bonding is not something, as the High Court said, Sutherland J said, it's not something that the BCA is focused on. It may be something that the Children's Act would devote more attention to, but these are minimum employment standards. So one I think can infer, I submit, that these time periods were there to promote breastfeeding, as I've suggested.
Thank you.
Can I ask something if my brother is finished? Sorry, ACDCJ.
Oh, just to make sure I understand your argument, Mr. Boda, you've been emphasizing financial implications. I want to understand if you emphasize those, and this is with regard to interim relief. I want to make sure whether you emphasize those even in respect of the Van Wyks and CGE's position with regard to a shared 4-month period.
No, so if the period's not going to increase, it could have minor financial implications depending on who earns a higher salary or not. But it's not going to. I can't imagine that would be devastating.
So in that regard, your opposition has nothing to do with financial implications.
No, the other proposal to extend it to 4 times 4 years, it would fall in there, but not on the Van Wyk suggestion to retain the 4 months. It's not going to cost anything more. I mean, it may be. Depends who earns a higher salary, but
you've answered me. You've answered me. Thank you, my brother, Justice Majid.
Thank you, ADCJ. Mr. Boda, I'm deeply concerned about the way you approach the litigation in this case. I mean, as counsel for the applicants and for the CGE and Sonke, I think not Sonke, but the other two have submitted this condemnation application comes against the backdrop of a notice to abide. Now, I understand the timeline that a new minister took over and new senior counsel was appointed and so on. But here's what's bothering me. You say that you make this affidavit to assist the court, but I say it with deference and respect to you. I think it obfuscates matters greatly, and you will understand from the debate this morning thus far that this is not an easy matter as far as remedy is concerned. But listen, look at what you say in the condemnation affidavit. And I'm reading at page 8, paragraph 35, where you're dealing with, in the affidavit, the minister deals with prospects of success in the context of condemnation. It says this. Now, this is after the minister has now taken a new view of the matter, or senior counsel has advised the minister. The minister says the minister has already filed a notice to abide, and the issues of prospects of success, I submit, do not come to the fore in this condemnation application. And then over the page at paragraph 36, this is what the minister says. Well, not the minister, but Ms. Maponya on behalf of the minister. Since the minister is not opposing any of the relief sought and is making submissions related to the relief and assisting the court on any points of discussion, the minister may be called to answer. I submit there's no prejudice suffered. Now, this is not true. You vigorously opposing this interim relief So when you say you're not opposing any of the relief sought, that includes the remedy. So how does a court approach this kind of affidavit for condemnation where the minister blows hot and cold, supposedly to assist the court?
So I think this condemnation affidavit was done after the heads were delivered already. So
Yeah,
it
that
assumes
makes it worse.
I know, but I mean it was all done. I can't take it further. Just
Well, Mr. Boda, it's not as simple as that. You see, here, there are also some other problems, and I think in the supplementary written submissions of the first and second applicants, it's pointed out. Apart from the fact that the minister blows hot and cold, saying she abides, but then vigorously opposes the relief in terms of the interim relief in terms of the remedy. There are also submissions in these written submissions that are wrong, as the first applicants have pointed out. I mean, can you, for example, show me where in the judgment of Sutherland DJP, he says that other jurisdictions accept, and the court accepts that other jurisdictions regard legislation as the only way to cure the kind of difficulty we are dealing with here. And I can take you to,
yes.
I can take you to their written submissions. Perhaps I should do so. Let me just get it. They say in paragraph 12, page 5 of the supplementary submissions, the High Court did not find that 12.3, that the legislative function is the only mechanism through which to determine parental leave systems across various jurisdictions, and their footnote refers to paragraph 37. Your written submissions, and I've cross-checked it, and that's exactly what you say. But can you point to me in the judgment where Sutherland DJP says this?
So I think it is reference to paragraph 30, where the learned judge says no country which has provided such employment benefits has done so other than by way of statute. That's what one had in mind.
And can you show me where the court says that, I'm just gonna get there, at 12.2, any changes to parental leave entitlements will have an obvious financial impact. That's paragraph 42 of your submissions. Can you show
paragraph
me where
38. Paragraph 38 says there.
Let me just go there.
The second, there is an obvious direct financial impact
Yes,
on
I
the
see
UIF.
that. I see that, but that, of course, is on the basis, just to digress, that it's on the basis of how the High Court saw it, that there's a direct financial impact. I must tell you, I don't see it, because you've already conceded there is no evidence of this.
No, I've considered that we haven't assisted the court in providing data, but I think the financial impact of some of the amendments are obvious. It's going to increase the amount of contributions.
It's not that obvious to me, but finally, in 12.1, the manner in which the impugned provisions apportion leave is constitutional. Now, this is very important. The submission you make at paragraph 14. Where does the High Court say this?
Sorry, just bear with me.
Certainly.
Just repeat that. I didn't get that.
You make the submission at paragraph 14 of your written submissions that the High Court did find as a fact that the manner in which the impugned provisions apportion leave is constitutional. Can you show me where the DJP says that in its judgment or finds that?
No, I think it was only probably a reference to the adoption part, not nothing else.
Yeah, well, it's misleading. So what is the minister's position? Does the minister abide, or does the minister oppose the interim relief? Because you can't.
The minister is putting. My instructions are to put the minister's concerns about the interim relief to the court for its consideration, and the court and the court, whatever the court decides, that is it. I've tried to do that to the best of my ability, and that's as far as it goes. I had 2 meetings to try and get clear instructions on what the situation is. It's in the affidavit, and I mentioned this, that given the pressures with the notice of set down coming before all of this sorted out, we did heads. We sent it to the minister for approval to see if these heads are accord with our instructions, and we were told that these heads can be filed as being what the minister wants to place before the court. And I
Mr.
can't take
Boda,
it from
I understand that you placed in an invidious position, but we're in an even more invidious position. We must write a judgment in this case. There was a judgment in this court where Cameron J, I can't remember which case, it may have been Mvumvu, where Cameron J said more is expected of government as a litigant. It is not a bewildered litigant at sea as to how it should proceed.
Curland, my brother.
Curland, that's the one. Thank you, ADCJ. In Curland, that's what this court said. And so I understand your difficulty, but you must understand the court's difficulty even more. But let me get to this then. What is your objection on the basis that, and I don't mean disrespectfully, on the basis that you appear to be straddling two chairs? What is the opposition of the minister to the basic relief that the first two applicants, the Van Wyk, seek in this matter? In other words, they simply seek a declaration of invalidity, to be suspended for 2 years, and that the parents, biological parents, share 4 months leave, parental leave. Do you have an objection to that? And if so, what is it? Can you explain to
So the consent arrangement is what I've addressed in the five problems I've highlighted, which I think I've addressed.
Yes,
there's a problem with that. There's policy problems with it. Because whatever interim relief the court grants, obviously the court can't grant relief for the Van Wyks for these set of facts. But for the general population, they're not in that same circumstance where there is a cooperation between the two spouses and there seems to be an equitable gender balance in the family. But that's not going to be the case for everyone else. So if one is going to make a general interim relief subjecting the regime to an agreement, the parties could agree to something even worse, less time for the mother than what she's presently getting.
Well, that's for them to decide. What your submission boils down to is this: you accept that this provision is constitutionally invalid, because at the very least it infringes the right to equality, at the very minimum. But you say we must let parties continue with this constitutional invalidity, with this inequality, for the next, I don't know how many years, well, let's say 2 years, and there's no interim relief. That is what you are submitting, isn't it?
Yes, I'm submitting it on the basis that if one looks at the ILO international standards for maternity and paternity benefits, the present legislation as it is does not offend any ILO standard. So the ILO standard for maternity leave is 14 weeks. There's a recommendation of 18 weeks. We give 17.23 weeks. So we are not offending any international legislation. And because of all of these competing interests, one doesn't want to grant interim relief that's going to backfire, that's going to create the same problems that are being objected to now. So the type of interim relief fashioned by the High Court, where one leaves it to the parties to agree, could conceivably result in the same prejudice or same arrangement being agreed to as the legislation. But just because they agreed, it's not constitutionally objectionable. But that agreement, is it a true agreement? That's the question. And what happens if they can't agree? There must be a default position. So what happens? Parents don't always agree. So what happens if there's a marriage where the parties are at loggerheads and they're separated and they're going through a divorce? They can't agree, then what? What interim relief do those parties get? And the only interim relief those parties get is a standardized formulation, which should be left to Parliament. The current leave regime is not out of kilter with international law, with ILO standards, and we're really only fighting about the 7 weeks. So nobody disputes that for maternity leave, the first 4 weeks should be the mother's right to prepare for birth. Nobody disputes that the 6 weeks thereafter should be the mother's right to recover. Nobody disputing it. So one is left with the 7.23 weeks that we're talking about. So that's where the imbalance is, and it's something that I submit can be tolerated given the fact that it's not out of kilter with ILO standards. It needs reform. We're not suggesting it doesn't. It needs reconsideration. Parliament accepts it needs to look at all of this, especially the facts in the Van Wyk case has thrown up something which maybe perhaps no one considered. So how does one manage that? So
You see,
those are my...
if all things being equal, I'm just concluding with this, Mr. Boda. The difficulty for the court is this, for me at least. All things considered, this application for condemnation gives neither an adequate explanation as far as I'm concerned on a prima facie basis, nor does it answer the question of prospects of success because you're supposed to be abiding. And so all things being equal, this condemnation application should be refused. But where does that leave the court? It leaves the court then with a situation where the minister has made no submissions before the court. And the court can't just simply fold its arms and close its eyes and say, well, we'll let be what's be and let the High Court judge order stand and adapt it, recraft it where necessary in terms of our 1721B powers. But that is a wholly unsatisfactory situation. And I know what you're going to say. You're going to say, well, it is just the turn of events of all what has happened with your late briefing and so on. But it does leave us in a real conundrum. I'm sure you can see
that. I agree. I can't take it further, other than to say that all we can hope for is that whatever submissions were made can assist the court one way or the other in its deliberations. And if the court finds it useful, then the court should admit it. If the court finds it not useful, then the court should deny condemnation. That would be the ordinary.
Thank you. Thank you, ADCJ.
Thank you, colleagues. Thank you very much, Mr. Boda. Now it's time for replies. Ms. Rajab Patlenda.
Acting Deputy Chief Justice, I believe we haven't yet heard from the amici. Would you like us to deal with reply before that?
No, remember at our meeting this morning, I said they were granted leave to file written submissions only.
I'm so sorry, I misunderstood.
And you remember they even said they were asking for 5 minutes and I said not.
I misunderstood entirely. Please forgive me, but I am ready to start with my reply.
Thank you very much.
Let me start, Justice Madlanga and Justices, with the Minister's argument. Having listened to the Minister's Counsel now, I'm afraid I'm more confused than ever. Because on the one hand, the Minister says that she wants the order confirmed without interim relief. But then the Minister's Counsel also spends a lot of time in argument saying there are problems of unequal power balances that make the sharing arrangement contemplated by the High Court problematic, so that it should not be confirmed. And I think this actually summarizes the problem with the Minister's participation in these proceedings. And I'll say no more than this. I repeat my submissions that the Minister's conduct should be sanctioned in these proceedings because it does set a very worrying precedent about how the executive is entitled to behave in this court. The effect of the Minister's argument is, if I understand it correctly, is that the legislature is trying to protect women in these unequal power relationships. But in the same breath, the Minister is willing to accept that no interim relief must be granted, and that has the effect of leaving all mothers with no leave for at least 2 years, and certainly it has the effect, at a minimum, of providing no relief to fathers who would want to participate in the rearing of their children in the first few weeks. How does that possibly protect women? So the fact that the Minister says that the current system accommodates some leave for all categories of parents suggests that the Minister is now saying that she thinks the act is in fact that the act is in fact constitutional because it provides some leave for all parents. That's a submission that's in the written submissions, and it was made also in oral argument. with all due respect, the minister must choose what role she wants to adopt in these proceedings. And then the argument about this being some kind of a private contractual arrangement, I think that was the language that my learned friend used, a private contractual arrangement between the parents. This is not a private contractual arrangement. This is a situation in which the legislature has chosen to provide leave to parents after the birth of a child, but has done so in a discriminatory manner and has discriminated between men and women. So we would submit that the court must declare the relevant provisions unconstitutional. And in crafting the relief, we would submit that this court should not leave parents without protection to cure the unconstitutionality while Parliament decides what to do. It would be an extraordinary outcome for this court to find an unconstitutionality but offer no protection in the interim. And I've referred already in my main submissions to the various cases, Bay and Amabungani among them. And I would submit that this court must fashion what this court has referred to as a creative remedy and not self-censor. Now, I've said before on the question of what interim relief would be appropriate, that what's clear from the debate today is that it's unlikely that the court is going to make interim relief that is absolutely watertight or that meets every possible family situation. So instead, what we suggest this court must do is to focus on remedying the discrimination and putting in place interim relief. And this can best be done in our submission by using our interim reading in that we suggest, together with some additional language that I will read to you shortly. If I was in court in person, I would hand up a copy of a revised interim relief, but we can certainly email that through this afternoon after court. To just explain the context in which what I'm about to propose, the context for making the submission, it's this. First, we need to deal with some of the issues raised by Justice Rogers and Justice Majid, I think it was. The first is, if one were to use the concept of just a permanent partnership, like a life partnership, that's not enough to plug the holes or the gaps that remain, because you may have situation in which you have divorced parents, parents who don't live together but are co-parenting, for example. So you've got to cater for that. Next, you need to deal with what I call the deadbeat dad, if I was American, i.e. someone that doesn't financially or otherwise provide for the child and is not involved in the child's life. And then third, you need to address a situation in which parents can't agree on who takes leave. Now, this will only arise if both parents want to take leave. It's unlikely in our submission, given the context in which parenting happens in South Africa, but you never know. We're optimistic that there'll be a shift in gender roles. But you have to address that. We also have to address the minister's concerns around unequal bargaining power that women experience. And so we're trying to work that into the formulation. So the interim reading in that we propose is as follows. Section 25 would read as follows. An employee who is given birth or whose partner, and then in brackets, who assumes parental rights and responsibilities over the child as contemplated in the Children's Act. I'm afraid I don't have the reference for the Act. I've left that out by mistake. Has given birth, is entitled to at least 4 consecutive months leave after the birth of the child. That's paragraph or subsection 1. We then suggest that we add in a new subsection 1 capital A, so it'll be 25(1) capital A, which would read as follows. In the event of a dispute between the birth-giving employee and her partner over the apportionment of leave entitlement provided in subsection 1, the employee who has given birth may make an election with regards to how much of the 4 months leave she intends to claim. The partner may then make an election with regards to whether they wish to utilize the remainder of the 4 months leave. Now, the language can, of course, be finessed. I don't suggest that that is the best language, but the point of it is this, that one of the concerns Justice Rogers raised with me was about a situation, a dispute resolution situation where parents couldn't agree. Now, I think in that situation, Justice Rogers, you suggested that we put in a default position that the mother would get the leave. That unfortunately could well find its way into all sorts of issues around that feed into the discrimination. So instead, our thinking is that if one were to give the birth mother an election of how to split the time in the event of a dispute, that would resolve the concerns around discrimination against women. I don't suggest that this is a foolproof reading in, but I do think it attempts to deal with some of the concerns identified today. The primary relief that we seek this court to make is to cure the discrimination between mother and father. We accept that there's never going to be, as I've said, a watertight reading in, but it is for an interim period, and it is just that, interim. And where there are difficulties, it will assist the legislature in finding a way through those difficulties ultimately. And then the last thing I just want us to assist the court with is Justice Theron asked me a question on the minister's budgetary argument around an amount of 3 billion rand. I just wanted to let the court know the only 3 billion that we can find actually comes from a quote, which I think comes from the Mvumvu case. It's at paragraph 101 of the minister's submissions. So it's not, in fact, the minister's, it's not a submission of an amount of money relative to the UIF at the moment. We don't have any of that evidence. But the minister has actually failed to address why the High Court relief as it currently stands increases the UIF liability. If anything, it reduces the cost because it doesn't provide for the 10 days that a father would have had. So in those circumstances, it's very difficult to understand. In fact, in all of the circumstances, it's very difficult to understand why the minister wouldn't simply agree to confirm the High Court order.
And your time is up. Thanks, Ms. Raja, but Linda, colleagues. Thank you very much, Ms. Raja, but Linda, Ms. Barnes.
Thank you, Acting Deputy Chief Justice Madlanga. Let me start with where my learned colleague left off. And there are two issues there. The one pertains to the definition of parents in the Children's Act. We would endorse that proposal, that any interim relief that is granted by this court make reference to that definition in order to clarify who the parents are in this situation. With regards to the consent problem, as Advocate Boda put it, we have a few submissions to make in this regard. Firstly, we submit that much of this is with respect speculative and exaggerated. This idea that parents will not be able to agree and so forth. And to say that because women have historically been in a position of weaker bargaining power, therefore they should effectively have none going forward, because that is the consequence. If they do not have the right to make these decisions in the interest of their own equality and dignity, then they have none. So we submit that women are, in terms of the physiological impact of childbirth, they are already protected by section 25(3). They can't go back to work 6 weeks after the birth of the child unless there is certification to the contrary by a doctor or midwife. So they have that protection. For the rest, all that is being asked in terms of the interim relief here is that the standards apply across the board. And let's just break that down for a minute because it's important. So in terms of the current legislative regime, the standard for biological mother is 4 months and father is 10 days. So what we are saying in the first instance is every mother, not just a biological mother, gets the 4 months. Then when we're dealing with a couple, we are saying that every couple must get the 4 months plus the 10 days. Remember previously, well, in terms of the current regime, adoptive and surrogacy commissioning parents only got 10 weeks. So that 10 weeks, that period increases. So either where there's a couple and they take the 19.32 weeks, every couple is entitled to that. Either they can share it or they can decide who's going to take it. And of course, that is all subject to Section 25(3), which says that a woman cannot go back to work 6 weeks after childbirth. So that must be factored into their arrangement. For the rest, we submit that the couple may be permitted to determine either that one or the other is going to take the leave, subject to the 6 weeks, or that it's going to be shared. And let's remember, let's look at the provisions currently as they pertain to adoption and surrogacy commissioning. The provisions currently say that where there's if there's a couple, one adoptive parent can take 10 weeks and the other one gets 10 days. The same in respect of surrogacy commissioning. One can take 10 weeks and the other one can take 10 days. The law does not say who must do what. I mean, there's no prescription there. In relation to those couples, they must choose. One takes the 10 weeks and one takes the 10 days. There's no suggestion that this is unmanageable or impossible or will result in a flurry of disputes. And so we submit that exactly the same principle applies to the equalized position. Parents, let them choose how they want to structure their lives, and that will be constitutional. And that's a perfectly reasonable and permissible remedy to craft in the circumstances. So that's what we would say with regard to the consent, the so-called consent or dispute issue that's been raised. We submit that there would be no reason to adjust the interim order granted by the High Court as far as that is concerned. If I might just deal quickly with the distinction between nurture and bonding. Now we have two important points to make here. The first one is that we submit with respect that these things happen together, and to attempt to draw a dividing line between them is artificial. Just in the same vein that bonding does not stop after 4 months, neither does nurturing. Both of them continue post 4 months. The purpose of the 4 months is to allow both to happen in a focused manner. Bonding must be a co-purpose of parental leave. Otherwise, parents would simply have a third party take care of the physical needs of their children. Obviously, bonding is part of what happens, and bonding and nurturing continue after the 4 months. Now, importantly, the minister said in its answering affidavit, supplementary answering affidavit in the High Court, the following in relation to the purpose of these provisions. And we find this in volume 12, page 843, paragraph 102. They say, at the core of legislatures considering the need to amend legislation to cater for parental leave, adoption leave, and so forth, was the consideration of acting in the best interests of the children, encouraging adoption, and advancing healthier families and society as a whole. So those are the purposes acknowledged by the minister herself. Best interests of the children and advancing healthier families. And obviously bonding would be incorporated into that. So we stress that nowhere has the minister said that nurture is the only purpose here. On the contrary, they have indicated that those are the purposes of the sections, and that obviously includes bonding. And then just finally, it wasn't entirely clear to me in your exchange, Acting Deputy Chief Justice, with Mr. Boda, whether the concession in relation to the fiscus applied to CGE or only to the first and second applicants. So let me just quickly deal with that. Remember that when you've got biological parents sharing the leave, there's no difference. It's exactly the same. The only difference would be
my focus was just on the 4 months. I didn't go to the adoption and so on and so on. Yeah,
yes,
please continue.
Yes. Well,
yeah.
Thank you. That's helpful. So the only difference there would be that, now remember, this is already a tiny category of person, surrogacy, commissioning, and adoption. It's minuscule. The only difference there would be that the 10 weeks would move from, it used to be 10 weeks and 10 days. And now that would become 19.32 weeks. So that would be the only increase. That would be the only impact on the fiscus in terms of the High Court's interim order, and we submit that that is minuscule. In addition to that, there's obviously no proper evidence before the court. And then just finally, this is a case where the causa principle applies. It's a case where the financial benefits that are being distributed cannot be done so in a way that displays naked preferences. That's happened here. The High Court found that it happened. And in those circumstances, despite the impact on the fiscus, those benefits must be distributed equally, even if that means a reduction in benefits. That principle we submit finds direct application here. I'm not sure where I am in terms of my 10 minutes, but I think those are my
two minutes to spare. Thank you very much. Thank you. Ms. Letzler.
Thank you, Chief Justice or Acting Chief Justice. Just in terms,
Deputy,
I'm sorry, Ms. Letzler.
Deputy.
I keep on forgetting I'm muted. With your leave, Acting Deputy Chief Justice, may I ask Ms. Barnes to just repeat what she said, the point you started with concerning the definition of parents in the DCEA.
In fact, Ms. Barnes, I clearly forgot to invite colleagues to put questions to you. My apologies, colleagues.
Thank you, Justice Cheeky. The position there, I just wanted to indicate the CGE's position there, and that is that we would endorse that additional definition in the Children's Act being incorporated into the interim relief to make it clear who the parents are in this context.
Okay, thank you very much. Thanks, I'm covered. CCT.
Any other questions, colleagues? Thank you, Ms. Barnes. Thank you very much.
Thank you.
Thank you. Yes, Ms. Letzler?
thank you.
Don't you have more than one device at the same place?
Apologies, Deputy Chief Justice. I don't seem to, I can see my face on the screen here, but not on your screen. I don't know if you can see me.
I do see you.
Yes, thank you very much.
But I see two of you, yeah, one with a video on, another without a video on.
Yes, the one without the video, we are struggling to get me up on the video, so I'm on a separate laptop, so I'll speak from that one.
Why don't you switch off the one where you are not on video, please? Okay, okay. Okay, your time starts now. Uh-oh. Now we can't hear you.
She's muted.
Oh. Yes.
Thank you, Deputy Chief Justice. Can you hear me now?
Yes, loud and clear.
I think the first aspect I would like to just highlight is that we do not agree with the position put before this court of Ms. Rasha Butlender for the first and second applicants for the very reason that it then excludes the 10 days that the male part has, or it forces the mother to return to work before the 6 weeks is up, or that she has to stay at home alone for the 6 weeks. So in that regard, I agree with Ms. Barnes' contentions that the 6 weeks has to be separate and seen separately. If there is to be given any sharing of the rest of the leave, that the 6 weeks need to be seen as a separate entity, either as a period or a postnatal period. Then in terms of the argument made by the minister and in terms of the arguments put forward on proposing a sharing of the leave, I think that the minister made out a very strong case as to why there should not be sharing and why each parent should get their own leave period to spend time nurturing and bonding with a child. But I do agree with Ms. Barnes in this respect that, or with Ms. Rasha Butlender, that our courts already make provision for mediation processes. Matrimonial law already makes provision for mediation processes. So if there is a dispute, there already is a resolution for something like that.
But I think if one really has concern of the power that women may have, that they may not be in a position of power to argue if they could keep their leave or if the husband should take it, then it's obvious that each party should have an equal amount of leave. And that cannot be over and above that cannot be separated from the 6 weeks, that the 6 weeks in itself is a period that is medically required and that the mother cannot share that with anybody else. I have nothing further. Thank you.
Thank you, Ms. Lesler. Colleagues? Thank you, Ms. Lesler. Mr. Boerder, I assume you might want to reply because some of the council, I think, especially Ms. Rajapalenda, touched on whether the minister should be participating at all. Any reply?
Deputy Chief Justice, I think I've said what I want to say.
Thank you.
I mean, I'll leave it in the hands of the
you.
court. I just hope the submissions did assist the court. Anyways, if they did, then please allow it. If they didn't, disallow it. That's as far as I can take it.
Thank you. Thank you, Mr. Boerder. Thank you to all counsel. Judgment is reserved and the court adjourns.
As it pleases the court.
Today's proceedings have concluded. The host will now terminate the meeting.
Thanks, Ms. Pero.